The rejection of the bid of the petitioners filed the impugned order dated 18/11/2019 is basically on two grounds, namely 100% actual fisherman certificate was not issued by the appropriate authority, that is the ARCS of the concerned district, and secondly, the ground of neighborhood with the finding that majority of the shareholders of the petitioner society reside at village Niz Govardhan, which is situated at 1 kilometer distance from the fishery. So far as the first ground is concerned, the same appears to be a perverse ground, inasmuch as such certificate issued by the ARCS has not only been annexed to the writ petition, but there is also a fair disclosure by the learned state council that the original records indeed contain such a certificate. An attempt was made by Sri Botha Court that the state certificate as annexed 6 to writ petition. The same states that the members of the society are in the neighborhood of certain mahals which do not contain the name of the present fishery. However, the purpose of the state certificate and the objections raised pertains to the question of issuing authority as well as the purpose. In the instant case, the issuing authority is the ARCS of the concerned district, and the purpose is to certify that all the members are actual fishermen. Therefore, the objection raised by Sri Botha Court may not be relevant. As regards the second ground, namely neighborhood, the findings arrived at in the impugned order is that majority of the shareholders of the petitioner society reside at village Niz Govardhan, which is situated at 1 kilometer from the fishery. The list of members along with their address would show that other than the village Niz Govardhan, there are other villages also where the members of the petitioner society reside. The mere fact that certain members are residing at a distance of 1 kilometer cannot govern the fate of the society. Further, the decisions relied upon by the petitioners have laid down in clear terms that while ascertaining the requirement of neighborhood, the same cannot be done in minute mathematical precision, and the requirement is only that the actual fishermen belonging to the scheduled caste community residing in the vicinity should get the benefit. In the opinion of this court, such requirement cannot be tested in a golden scale and would depend on case-to-case basis. This court is in humble agreement with the interpretation of the expression neighborhood in the context of Rule 12 made by the Honorable Court in so-and-so. This court is also concerned with the public interest involving in the settling process with a settled position of law that in matters concerning distribution of state largesse, which are mainly for earning revenue, the public interest is to be given priority. This, however, may not be interpreted to mean that a bid which is grossly defective and not meeting the essential criteria should also be considered. However, in the instant case, while rejecting the bid of the petitioner number 1 on the grounds which appear to be unsustainable and trivial, the aspect of public interest has been totally overlooked by the department. A bare perusal of the financial bids offered by the petitioner and the private respondent would reveal that there is a difference of about rupees 22 lakh, and this is a relevant factor that should have been taken into consideration. They have cited some case laws. This court has also taken note of the fact that the original record contained a report from the circle officer who had recommended the settlement in favor of the petition number 1, whose bid is the highest. Not to talk about assigning any reasons for discarding such report, there is not even a reference to the state report in the impugned order. So, under the opposed facts and circular, court is of the unhesitant opinion that the impugned action of the respondent authority in rejecting the bid of the petition number 1 and accepting the bid of the private respondent for settlement of the affair in question by the impugned order dated so is unsustainable in law, and accordingly the same is set aside. Authorities are directed to grant settlement of the petition number 1 at its offered price. Some more observation. Original records are returned back.
May I please, Your Lordship? Back to mention item number 49, Your Lordship.
Yes.
Your Lordship, is a provincialization dispute. The petitioner has already 63 years. Is no longer interested to continue. Your Lordship, I am making mention on behalf of JMUN Law School, and I have taken consent of DA Kayo. He is here.
40?
49. 49.
Okay. Sri R. Mazumdar, learned counsel, appearing on instruction of Sri JUNM Laskar, submits that by flux of time, there is no life for the action to be adjudicated. Also heard, secondary education, Sri B. Kaushik, Learned Standing Counsel, Secondary Education, and Sri D. A. Kayum for the Learned Counsel for the response number 6. The writ petition accordingly stands dismissed as infractuous, has not pressed. I also present. Yes.
There is I.M. Miller. My lord, I beg to mention for item 8, my lord. My lord, I need some accommodation, my lord. I want to do this case at the second half, my lord. I have taken consent of the other.
Okay, so we'll try for second half.
My
8. Two
My lord, I beg to mention the last item of the supplementary list, my lord, item 56. But in this case, my lord, the petitioner has already retired, and my lord, he has instructed me, my lord, not to raise the petition. On instructions, lordship may close it, my lord.
Sri S. K. Talukdar, Learned Counsel for the petitioner, submit that due to flux of time, there is no case, no life for the victim. Also heard this is higher education. Who is there? K. Gogoi, higher education, and anyone for the private respondents? Chamwa, is he there? Chamwa, is he there in the court? Hey, Chamwa.
I can inform.
Is he there in the court?
Now,
If he's not there, we'll not record. But we are taking it out of turn. If he's there, kindly inform. Okay. Hey, Chamwa, for standing as UGC. That's okay. Hey, Chamwa, that is standing as UGC. Take it to not bad. Yes.
item number 6, the petitioner has already got released.
6.
Some inspector.
Yes. M. Khan, for flux of time, no life for the victim. Secondary education, we have B. Kaushik, infractor. Yes.
I beg to mention item number 16 and 17, my lord. I have taken consent of the petitioner, my lord. Kindly adjourn for the day, my lord. I am for the response number 5, my lord. In item number
16 and 17.
16 and 17.
16 and 17. On a prayer made on behalf of the petition number,
Response number 5, my lord.
response number 5, matter can be adjourned by 1 week. 16, 17, 1 week.
May it please your lordship, I beg to mention item number 43, lordship.
Yes.
Lordship, kindly list the matter after vacation, lordship. In this case, lordship, appeal is pending, lordship. I take the consent of the respondent.
You're for the petitioner.
Lordship.
MSR Decca, Learned Counsel for the petitioner, submit that an appeal against the judgment and order of the learned single judge is pending. Accordingly praised for adjournment of this matter. List of notifications.
Obliged.
Yes.
May I please, lordship? Item number 4 and 5, my lord.
Yes.
This matter may come, my lord, after vacation, my lord.
It's a 17 matter, Mr. Kohai.
My lord, some petitioners already retired, my lord, from his service. But date in a year, I am not sure, my lord. I am contact with the same.
There is no some petitioners. In item number 4, there is only one petitioner. In 5, there are 4 petitioners.
Yes, my lord. And some of the petitioner already get some relief, my lord. Part payment. These two
You grant
matters
you
are
time till
regarding
Monday next. Get telephonic instructions. We'll dispose of this matter. 17 matters. Sri A. Gohai, Learned Counsel for the petitioner, prays for some time to obtain instructions as to whether there is any life for the victim. Considering that these cases are pending since the year 2017, a short adjournment is granted, directing listing of these cases on Monday. Next Monday.
Monday, some problem. My lord.
Then Wednesday next.
Yes.
Next Wednesday, come. 1 week we are giving it. Wednesday. Huh?
May I please? May I please? I will mention item number 2, my lord.
Item 2.
Item number 2, my lord.
Yes.
16 matter, my lord. I need some instruction from my client, my lord.
Why? 16 matter.
16 matter, yes, lordship. This matter has been listed after a long gap, my lord. Long gap.
Let the matter reach.
Provincial of service of the petitioner.
No, we cannot adjourn a matter of 16 after 8 years.
Next week, my lord. Only one.
Let the matter reach. Okay, next Wednesday. Come up with instructions.
My lord,
We'll dispose this of.
my lord.
A prayer for adjournment has been made on behalf of the petitioner. Full stop. Considering a same, huh? What matter? Then, Wednesday. 21st. 21st.
May please Lordship, I beg to mention item 54 of supplementary list. On the last
54.
occasion, Honorable Court directed us to contact our client. So we have sent our letter to our client, but we have not received any information, any reply from her. So matter may be listed on Monday.
As a last chance, madam.
Okay, Lordship, okay. Monday, date may be fixed.
You're Nanda.
Yes, Lordship. On
you
behalf of SC Vishal.
MS even on the learned counsel for the learned counsel for the petitioner submit that though a communication has been issued to her client, there is no response. She accordingly please for some more time. In the interest of justice, a last of further opportunity is granted. Directing the case to be listed on Wednesday.
Monday.
Wednesday, 2 more days. 21st. Yes.
May I please, Your Lordship? My lord, I beg to mention item number 49, my lord.
49 years.
49, my lord. This is IA, my lord, and along with WBC, my lord. Petitioner, my lord, this is matter regarding, my lord, provincialization of service. He has already, my lord, exceeded 60 years of age, my lord. So, my
This has
lord,
already been mentioned.
my lord, so, my lord, we are not pressing this matter.
Your friend has mentioned Mr. Mazumdar on your behalf. R. Mazumdar.
Already, my lord, withdrawn, my lord.
Yes. You have instructed your friend, Mr.
Yes,
R. Mazumdar. You have already mentioned. You want 2 orders.
Sir, my lord, I thought, my lord, he could not reach, my lord. Okay, my lord, deeply obliged, my lord.
We'll record your name then. You
My lord,
have,
his name may be recorded also. Deeply obliged.
yes.
May I please, Lord? As I beg to mention item number 44, Lord, the petitioner got relief, Lord. That may be closed. Lord. Sometime
A rekha, huh?
I am for the petitioner, Lord.
Yes, close. A rekha. Yes.
Obliged.
Yes, madam.
Item number 23, my lord. I beg to mention item number 23. Earlier, P. Saikia was engaged in this matter, my lord. Yesterday, I received this file,
For the petitioner.
my lord. I want some 1 week time may given, my lord, to prepare the case. Have to prepare.
You need so much of time to prepare one case.
My lord, 1 week time.
1 week to prepare one brief. That to only preparing for argument. We'll have it on Monday. MDAS.
My lord.
MS MDAS Learned Counsel submits that she has been newly engaged in this matter and accordingly prays for some time for prepare. Who's for the other side?
Restaurant. I'm on
The-
behalf of restaurant number 7 and 8.
The learned counsel for the respondents do not object to the same for prepare. Accordingly, list on Monday,
No.
19th. Yes.
Obliged.
May I please, Your Lordship? I beg to mention item number 39, my lord.
39.
Yes, my lord. We have filed one affidavit. My lord, that affidavit may
Yes,
call for
yes,
one.
yes.
Declare.
It may, please, Your Lordship. At the item number 47, Lordship, it
Yes.
may fix after 3 weeks, Your Lordship. It is because of the death of the older son of Ramchandra Sukia.
Okay, okay. 47. This court has been informed that there is bereavement in the family of the learned counsel for prepare. List after 3 weeks. Yes.
Alright.
3 weeks.
Please, Your Lordship. Lordship, this is 2018 matters, item number 10 and 11. I need a slight accommodation, Your Lordship, for 2 weeks, Your Lordship.
2 weeks is too much.
The reason is that some of the petitioners have withdrawn and some of the petitioners have been accommodated. So I need a
No, Wednesday next.
Your Lordship, there is one more petition 8813 of 2018. That may also be listed along with this. These are similar matters.
3 R. Sinha, learned counsel for the petitioner submits that instructions are required to be taken as there has been some development. However, considering that the petitions are of the year 2018, a short adjournment is granted. Directed listing of this case on Wednesday, 21. List along with
8813 of 2018.
yes,
And
10
21.
and 11. 10 and 11.
Yes, sir.
Lordship on
Deep
21.
21st.
May I place a lordship? Lordship, I beg to mention WPC number 2334 of 2023. Lordship, the matter was listed on 3/5/2023.
There is a senior bench too. You have to go there. Police, not before this bench. Yes.
Let the no affidavit has come forth
Yes, Lord,
as yet. And the matter,
may I pray for 2 weeks time for filing order?
let the time has been granted and time is cutting out. Then nothing fruitful has
What is the
resulted.
what is the cause of action?
The cause of action has already been decided. What happened here? In 2020, state government in the education department issued 2 advertisements. One is for DE, other is by assessment for filling up LPUP research and assessment. They put a condition that this central that past candidate
Oh yes, yes. So this
shall not
issue.
be allowed to.
Okay. This issue has been decided.
Yes, that has been decided. Now,
And Supreme Court has affirmed it.
yes,
And
That's what is-
what happened? This Honorable Court in division bench directed that 916 posts in total. SSA and DE. Those should be filled up from among them. And there was an order recorded by the civil judge at the very initial stage. Lordship has seen that order also. There was a commitment made by the state that once if the petition is allowed on the basis of the offline application, they are allowed to submit now. Their cases will be considered. There is no any difficulty. Will be this said, it is assured by Mr. Soikel and his senior counsel that even the writ petition is allowed, the candidates of the petitioners will be considered as per
Okay.
law on the basis of the.
Mr.
offline.
Kaushik, is there anything to object to this?
no, my lord, there now grievances that 916 posts, which was as per the direction of the Honorable Division Bench, my lord, we have advertised that 916 posts. Now their grievance in this writ petition is that we did not maintain the roster position in while advertising it.
Okay, 22 matter. We'll grant you some time.
Ma'am.
But file it within this time.
Ma'am.
Okay.
But
Third three.
so that they
Yes.
come up with, because ultimately before vacation is possible.
Third three. KK Mahanta.
I am appearing for respondent number 327, your lordship.
File your affidavit.
I have filed an affidavit, your lordship. We are also seated qualified candidates, and pursuant to the this advertisement, we have been called and our documents have been verified. And they are about to give the appointment, but because of an order of this honorable court that final results could not be outcome broadcasted or given.
How many of you are there?
Five. So
Okay. Wait for some time. Tell us.
We'll
take care of
our cases may be considered. There are sufficient number of vacancies, and we have no opposition to the.
Have you filed any application for vacation, modification? File an application, will pass orders. R3 KK Mahanta, Senior Counsel for the petitioner, who submits that the issue involved has been conclusively decided by this court and also affirmed by the Honorable Supreme Court. Court of 3 B. Kaushik.
Elementary, understanding of.
Standing counsel, elementary. What was the idea for implement? Elementary education. However, pays for further time to fight the affair in opposition. Also heard. Three. Your name has been shown. M.H. Laskar, the learned counsel for the newly implemented respondent numbers 57, who submits that affidavit in opposition has already been filed on 8/6/2023. Full para. When list of after 2 weeks,
2 weeks.
whenever filing of affidavit by the department.
High level.
May fix a date, so that.
Is there any interim order?
There is an interim.
Is it till the returnable date?
No.
Or till further orders?
Until further.
Until further.
No need for extending it. then.
Extending is
Extension is required.
because it was last in the next date of listing it was.
On that, we have to extend it.
Yes.
Interim order stands extended till the next date of listing.
Let the just fix so that they can come up with.
Tell us the date. List on Adhikman. 14. Will it might not be possible before the vacation. Let us not fix a date. 2 weeks.
Otherwise, it will go to any
No,
time.
it will go beyond the vacation because 28 you
Even,
don't
even beyond vacation, lot may fix a date.
list. Yes, that is proper. List on 19th of July.
19th. High level.
You get sufficient time.
My lord,
Yes, yes.
I'll do.
Maybe a last month and another will be made to.
Oh, but that will
To
remember.
the extent of that 916, we are not disputing. We have complied with the direction of the honorable.
Yes,
Reservation, we have advertised.
come up with an affidavit. Yes, next.
Apply.
Yes.
Please, your Lordship. Lordship, here in this petition, Lordship, we have challenged the gradation list prepared by the DO Dhupuri, Lordship. 31st August 2022, Lordship. But Lordship, some junior and underqualified person also, or name also appeared in the gradation list, Lordship.
Yes, who's there for the department?
But petitioner name is not listed in the gradation list, Lordship. This is the
Just a minute.
Initially, Lordship, petitioner was appointed in the 1993, Lordship, as assistant teacher of LP school. After that, Lordship, 2018, Lordship, petitioner Equitable was amalgamated with the ME school, Lordship, an MEM.
Please notice the issue.
Definitely.
This is a gradation of 31/8/2022.
Lordship, still, Lordship, no.
Notice has not been issued.
Notice.
We'll issue notice of motion.
Yes, sir.
Lordship, assigned some interim, Lordship. Therefore, some
Interim, what is the interim order?
portion of the gradation list, Lordship.
They want a stay of the gradation.
Will not stay, we'll say any promotions given will be subject to the
Subject
outcome. We'll protect your interest.
Alright.
Your A. Alim,
ALM, Lordship.
part 3A Alim 6, learned counsel for the petitioner. Petitioners, full stop. Petitioners, full stop, petitioners who are aggrieved.
Who also filed the appeal also, Lordship. Who also filed the representation before the Director of Elementary Education, Lordship.
Petitioners who are aggrieved by a gradation list dated 31/8/2022, published by the District Elementary Education Officer pertaining to upper primary teachers of ME schools and ME madrasa in the district of Dhubri. Full stop. The petitioners allege that the impugned gradation list contains underqualified and junior persons in the state gradation list. You have been left out or what?
Left out, Lordship. But Lordship, BO Dhupuri and DA Dhupuri, Lordship, BO Blessever and DA Dhupuri, Lordship, they are not accepting my application, Lordship. Assigning without any reason. They are only said that,
Para.
Lordship, earlier we were
Para.
appointed as a basic.
Where I issue notice returnable by 4 weeks. 3B Kaushik, standing counsel. Elementary Education Department accepts notice on behalf of
One,
numbers
two,
1 and
four,
2.
five,
1, 2,
six,
4, 5,
6 and 7.
6 and 7.
And for
Bokolial for response number 3. State Council. Let extra copies of the petition be served upon them by tomorrow. Let steps be taken for service of notice upon the response numbers 8 to
8 to 26.
these are persons against whom you have made the allegation
Yes, Lord.
by recent post-duty steps by Friday. We are giving 2 days time to take research. Okay. The Learned Council prays for an interim order not to act upon the impugned relation list put of para. The said prayer is, however, objected to by the learned objected to on behalf of the department of para. After balancing the equities, comma, though the operation, though no restriction is imposed upon the authorities who are the gradation list in question, comma, it is observed that any action taken on the basis of state gradation list would be subject to the outcome of the petition.
Oblige.
Three. P. Talukdar B. Bora. Itu case है इसके ना इतना पढ़ो ही नहीं हाँ ये किस वो ये दुनिया नगोटा है ना itu itu बोलो ini kalau mau di order di mana itu no naik next mau order pas ini similar over.
Huh?
Was this case listed recently last week or this week? No,
It
it was listed. Huh?
It was listed 2 days back.
2 days back, we remember this case for order on good.
Here the petitioner has already accepted.
Where was it last listed?
Last listed. I'll inform after something.
No, that order sheet is not here. We remember this. We passing some orders.
On that day petitioner was absent.
Understood. We remember that. So we had made an observation. Next day we'll pass some orders. মনে হচ্ছে মই order pass করেছি এটাকে complete list not person কেটে আছে list
And the petitioner perhaps he is not interested also because he has accepted the appointment as a tutor
no
pursuant to a cabinet.
understood. We have that was
Yes.
why we had made some observation
Yes.
at the last day. Was this the order sheet to nahi ba order sheet upload hoye na
Kalyani support.
11.5 কি of 2023 to আমার কোড করে তো order 11.5 11.5 করে 22 না না তারপর আইছে মই লিস্টত সাপোর্ট এখানে অর্ডার সাপোর্ট জানাই মই অর্ডার তো আপলোড হয় না লিস্ট কোন করতে হবে কত okay none appears for the petitioner petitioner on call. On the other hand, be Kaushik, learned counsel for the department submits that it appears that there is no live cause of action, full stop para.
Right.
In view of the same and in the interest of justice, let a further chance be given and the matter be listed on Friday next.
Right.
This Friday, huh? Oh, it is, huh? It is, however, observed that in case of further default, this court may pass appropriate order. পুরো একই ধরনের কেস দেখা যায়।
Well, kindly pass it over for the time being.
Seven tomorrow to put to 7 why? 17 matter
Will be taken up, my lord, and after some time, my lord.
you're making a mention on behalf of whom?
My lord, the brief is not with me, my lord. I am appearing.
Then
Brief is coming, my lord. That is why I take some time.
all of 9. B Gogoi P Saikia. That's for whom?
In terms of honorable court order, I was directed to file an affidavit by the erstwhile inspector of court. He has already retired from service, he was promoted. Accordingly, I filed an affidavit.
Affidavit filed when? Recently.
No, long back.
Your provincial under Sharma.
Province under Sama, yes.
That you have filed on 3/9. Last time M who has said that they have been recently engaged. Name shown or not? B Gogoi P Saikia.
His name has been shown. Earlier, Mr. Pavitra Soikia was there because he has become the government.
No, that we have understood. But last time none appears for the petitioner on call, whereas the department is represented by B Kaushik, the standing counsel. Dr. SK Das, current counsel has appeared for the response number.
Actually,
Are you a respondent? I think you're the headmaster. Are you the headmaster? Mr. Bhuya, where are you?
Colleagues in another court, Lordship.
There are 3 counsels, somebody has to be there. We cannot wait for you.
I understand, Lordship. And I apologize for that, Lordship.
Yes.
We'll still need some time to reconstruct the file,
Lordship, I was not a party here, but in terms of the honorable court order, Lordship, I was directed to file an affidavit because there are the contradictory stand.
No, who are you?
I am the erstwhile inspector of court. I was not party, but in terms of the inspector of the party, Lordship, in terms of honorable court order.
M Bhuya, Lieutenant Counsel for the petitioner. Please for some more time. Full stop. Also heard Sri B Kaushik, Lieutenant Counsel, the B Kaushik, standing counsel, and Sri SK Das, Lieutenant Counsel for the erstwhile inspector of school are present. This court is not inclined to accede to the prayer for further adjournment, as this writ petition is pending since the year 2018 for Kapera. However, in the interest of justice, a short accommodation of a week is granted to enable the learned counsel to take necessary steps. Please stop for a week. Don't ask for adjournment, Mr. Bhuya, next time. We'll go ahead otherwise. 12. Yes, who is for the petitioner? None appears for the petitioner. Item number? SAK. Who is SAK? None appears for the petitioner on. None appears for the parties on call. Sarah, in the interest of justice, please take in on Friday next. It is made clear that in case of further default, this court would pass the appropriate orders. It is standard result for you, not for next.
My pleasure. Lordship, I have completed my normal training course, Your Lordship, from Bongaigaon Normal School, Your Lordship, but my supplementary mark was not sent by the principal of Bongaigaon Normal School, Your Lordship, to the SCRT department.
Yes. Who's there for the department?
SCRT requirement.
SCRT.
On last occasion, Lordship, on 23rd, they were taking
Name
time to
SCRT
submit the
reflected or not?
reflected, Your Lordship. The cause list.
H. Aliha. He is the sending council, SCRT.
My lord.
Where is he?
After some time, my lord.
Okay.
It will
It is submitted as H. Aliha. Understanding council SCRT is not well. List on Monday next.
Yeah. Obliged.
publish.
Right. The third.
My
What is
lord,
this, Mr. Third?
in this case, my lord, petitioner was, my lord, initially
I think this will also go SCRT. We'll have it on Monday. He's not well. Same order. Huh?
Yeah.
We are for whom?
Follows the higher education.
Higher education. None appears for the petitioner on call, whereas as we are standing council higher education is present. We have also filed affidavit. Who submit that affidavit in opposition has already been filed. Put up para in the interest of justice. List again on Monday. Huh? Eighteen.
Yeah, please, Your Honor. Lordship, we don't have any contact with the petitioner for several years, Lordship. We'll get instruction
We'll close it, then we'll give you liberty. What is your name?
M. Burman, Lordship.
M. Bormon. MS M. Bormon appearing on instruction of MSA Gayan, Lieutenant Counsel for the petitioner, submit that there is no contact with the client for a long period, and therefore there is no instruction.
I am for the inverse.
Sri U. Sharma, Lieutenant Counsel, has appeared for the Guwahati University, whereas Mr. Talukdar for
Respondent number 4, my lord.
IA Talukdar appears for the respondent number 4. In view of the above, the petition is closed for lack of closed. However, liberty is granted for closed for want of prosecution. However, liberty is granted to the petitioner to file an application for revival if there is any existing cause of action.
Nice.
Good. I mean, good.
I'm sorry, my lord, due to the traffic jam and some last minute. The
Yes.
matters regarding to the appointment of the.
What has happened to your voice?
Absolutely.
Elections are very far off now. You're starting practicing for elections.
No.
Yes.
In the backlog vacancy, my lord, the total post was 134, my lord. Already the 170 post is fill up. 3 posts still is vacant, my lord. I'm selected to the district level, that is the district level. Covering the urban research next year. Is 28, my lord.
Well, just a minute.
Second.
Other similarly situated persons have been given relief. They been given granted the appointment or not? Appointed?
Already appointed.
Are you similarly placed?
Yes.
What do you say, Mr. Bora?
They have relying judgment of 2015, my lord. As per that judgment, my lord, is
At the time, my lord, it's a. It was.
may I read the judgment of 2017, which
But
they are
when was the recruitment drive initiated?
all my lord, 2005, 6,
2005.
2005, 6, can you come in 17? You were sitting on the fence. You saw what was the proceeding.
Till that was so many posts.
You were sitting on the
social
fence and you were
welfare,
watching the proceedings. Proceedings went in favor of the petitioners. Then 17, you rushed to the court. We don't think you deserve any sympathy.
They can file in contempt, my lord.
Hmm?
They can file in contempt at that point of time.
Their petition, they have come for the first time.
My lord.
Where is the question of contempt?
If they have participated in the process, my lord, they have not.
Which order? Which order they'll file contempt? Is there an order in their favor?
There
is only one petitioner.
2015. They were not.
He was not a petitioner.
My lord.
My lord, similar order also passed in the 2017, my lord.
17. But
17.
this is a recruitment process of 2005. You come to the court in 2017.
I'm waiting for the best post is taken. I'm waiting for attendance.
Not a quick case.
This 17 order is for different petitioners, my lord.
Understood.
Different petition.
That is what we are saying.
My lord.
He was watching the proceedings. When their case was in their favor, then he has come before this court.
My lord.
We thought we would be able to give you some relief, no?
My lord, direction to consider, my lord, the post is taken, my lord.
That is not the law relating to governing recruitment process. Posts are vacant will be considered on the basis of 2005 select list. You know better.
My lord.
My lord, the interim order also there, my lord. The one post is taken till further. 10/5/2023, my lord. Issued by an order dated 8/12/17 as an interim measure had directed to one post vacant in an 10/5/23.
Article Sudan counsel for the petitioner. Also article Sudan counsel for which department?
Elementary, my lord.
Elementary.
I am
Elementary
for
education
respondent of 5, my lord.
Put the
Newly
para-
implemented, my lord. And
Yes,
respondent of 6.
Who is
District
5?
5, my lord, Director Elementary Education, and my lord, District Elementary Education of respondent of 6.
Elementary education. Who submits that the respondent was 5 and 6 were subsequently implemented. Put the para- Considering the subject matter and the fact that this petition is pending since the year 2017, the same is taken up for disposal at the admission stage. Please have your seat. The case projected, the fact projected is that a recruitment process was initiated in the year 2005 by an advertisement dated 9/6/2005 for filling up 662 numbers of posts as backlog vacancy in the state for physically disabled persons, which was to be conducted in each district. Full stop. The petitioner who states who claims to be falling within that category now it is submitted that the petitioner who falls within that category was selected in the district level as well as in the state level, and 528 appointments were made, but the petitioner was not appointed. Full stop. It is submitted that there were inquiries by the government on certain anomalies. Full stop. It is further submitted that in the year 2011, some of the candidates had filed writ petitions in this court, which were disposed of in their favor. Full stop. This present petition has thereafter been filed in the year 2017. Full stop. The learned counsel for the petitioner has submitted that this court, while issuing notice by the order dated 8/12/2017, had directed that one post of ME school teacher in the district of Dhubri, earmarked for visually impaired, physically disabled person, be kept vacant. Bora, the learned counsel for the department, however, submit that the recruitment was initiated in the year 2005, and after 12 long years, the present writ petition has been filed. Also, he further submits that the select list has expired in the meantime, has spent its vote, spent its vote in the meantime, and therefore no relief can be granted. After hearing the parties, this court has noted that cause of action, if any, had arisen immediately after the recruitment process, when the petitioner was deprived of the appointment as claimed by him. Though certain persons had approached this court in the year 2011, it appears that the petitioner was sitting on the fence, and the instant writ petition has been filed after 12 years of the state recruitment process. This court finds forth in the contention made on behalf of the department that a select list of the year 2005, a select list pertaining to a recruitment process initiated in the year 2005, cannot be directly be acted upon after about 18 years. This court, being a court of equity, cannot lose sight of the aspect of examining the conduct of the petition, which is of immense importance. In that view of the matter, writ petition stands dismissed. Interim order passed, earlier stands vacant. Yes. Next.
Yes, I am appearing on behalf of ABT Hawk. Matter may be fairly passed for the time being.
Time being,
At two,
yes, you are there, Mr.
Lordship,
Gopal?
I am appearing for respond number 3.
Who are you?
The present assistant headmaster.
Okay,
Okay,
what is it you have to file your affidavit?
Lordship, we have filed on 2/6/22.
Yes. What is your stand?
Lordship, actually, Lordship, if we go to the Lordship, go to the
order impugned as challenge. Okay, that itself reflects the position of it. That
Page
is There's motive 30 and extra
0.
30 of the read petition notice. Notice this is the Korean now.
Hmm.
May I read notice?
Please read.
Please read the name of designated post of assistant headmaster in respect of Horakanda Kumar Deka in column 7 against serial number 22 as appears in government letter issued by dated 16/6/2016. Moreover, the name of designated post of ASM in respect of Horakanda Kolta as appears in column 7 against serial number 16 in government letter number 22 in hereby deleted as Horakanda Kolta retired on superannuation on 30/4/2017. The amalgamation was took place on 16/6/2017. On that date, the Horakanda Kolta was no more in the service. He's already
Superintendent 34.
lost.
Now, who is he? He is Maheshwar.
Mohasar.
Maheshwar, how is he connected? What is the relief he's seeking?
He is challenged on the ground that I am not eligible because I am from the MV school. Here it is written
What
as
is your name? Horakanta.
Horakanda Kumar Deka. It is written as ME school.
You are the assistant headmaster.
Assistant headmaster. Three schools were amalgamated, one high school and one ME school and one MV school. I am the headmaster of the MV school.
MV school, okay.
And then Horakanda Kolta was headmaster of the ME school.
ME, okay. He is gone. He is retired.
He is already retired as on the date of
and who is the petitioner?
Lordship, he is the one of the assistant teacher of the high school.
Okay. Now, after amalgamation, what has happened?
After amalgamation, that name has been thrown of the Horakanda Kolta as assistant headmaster.
Okay.
Amalgamation will take place on 16/6/2017. But he has already Horakanda Kolta has expired already on 30/4/2017.
Okay. In place of
inadvertently,
in place of Horakanda Kolta, your name has been corrected.
Lordship.
Now he is aggrieved.
Lordship.
What are the grounds?
Lordship,
does an assistant teacher of the high school get preference over the headmaster of the ME school or MB school?
Lordship, as part of the scheme, Lordship will find this.
You are now the assistant headmaster.
Assistant headmaster
of the amalgamated school.
Amalgamated school.
What is your claim?
My
You come prepared. Okay, after some time. You have the scheme of amalgamation?
Lordship. It is.
Okay, we'll let him come. Who is coming? Hawk? ABT Hawk?
ABT Hawk.
Mr. Dutta, what is it?
Well, the petitioner is selected candidate for the post of grade 4 minor. The facts of in nutshell, my lord, the petitioner pursuant an advertisement. He appeared before the reading test, my lord, with adjustment. But one unsuccessful candidate filed a petition before the Munchi Bilasipara. And expert status quo was ordered. And due to the expert status quo, my lord, the however was case was postponed. And in the meantime, SIU approval has expired. And thereafter, my lord, he was in however test, my lord, he was selected as a first selected candidate, and because of expiry of SIU approval.
What happened to the suit?
Mr.
What happened to the suit? You said there is a status quo expiry by the Munsif. What has happened to the suit? Outcome of the suit?
My lord, title suit, my lord. Title suit was dismissed subsequently.
It was dismissed. Okay.
Then thereafter,
In the meantime, the SIU approval had left.
Yes,
Now-
my lord, expired. My lord.
Okay, then
Then he could not be appointed because of expiry of SIU. Well, in similar case, my lord, this honorable court,
but the suit was dismissed on 2013,
13, my lord,
and
Yes.
you came to this court. You have come to this court in 2019.
my lord, in similar case, my lord, for an official communication was issued by the IS, my lord, in 2014, my lord, for grant of SIU approval. But in similar case, 2018, this honorable court first an order, my lord.
No, you say that this suit was dismissed in the year 2013, and the SIU approval was extended in the year 2014.
Up to extended up to 36 2013, my SIU.
So what about the communication of 21/1/2014?
My lord, 2014 at my lord at page 25, my lord.
Yes, what is your stand?
My lord, in my lord, a communication dated 21/1/2014. It is stated that on last paragraph, further it is to be mentioned here that SIU approval for 4 numbers of laboratory beer and provincial secondary schools was made during the 2010 5 year letter, so and so on, but no institutional guidelines has yet been received for filing the vacancy of and terms of the SIU approval has also expired. However, the said vacancy position of a laboratory bearer is also enclosed here, which the SIU approval.
My name was Son, my lord. Page 28, my lord. Serial number 7, my lord. There is one vacancy.
But from 14 to 19, you wait for 5 years to come to the court.
My lord, last occasion, my lord, this honorable court directed the finance department to take instruction, my lord, because in 2018, my lord, 38 2018, my lord, this honorable court directed the state respondent to examine the matter.
That is at the motion stage. We are on the admission stage. We are examining the entire case. From 14 to 19, what were we doing? 5 years?
I have filed it 2019, my lord.
From 14 to 19, 5 years, what were we doing?
My lord, they made some communication, official communication.
Where, what communication? Let us see. After 14 to 19.
As per my information.
Where are the communications?
14, I have annexed
After 14,
14, my lord.
2014 till the date of filing of your petition. What are the communications? We are dismissing this.
My lord, state may be directed, my lord, to examine the. But
If you are late in coming to the court, inordinate delay of 5 years in invoking your rights under 226, This is a code of equity, Mr. Doctor. Where is an explanation? You have to explain. We'll accept it. There's no explanation. Nothing. 5 years you lie low, then suddenly you wake up. Part 3 AK Doctor. Then it comes for the petitioner. Also heard to you, Sharma. Then it comes secondary education department. Para, considering the subject matter and the fact that this petition is pending since the year 2019, the same is taken up for disposal at the admission stage. Para. The petitioner claims to be selected by the School Management and Development Authority for appointment to a grade 4 post in the Rocka Khata ROK HS School, Dhubri.
My lord.
However,
My lord, on 2023 also there we have also communication.
23 communication and not do.
70. 17 also there.
There must be 17 communication. What communication? From them.
I have received a personal RTI application, my lord. The last page is
Where is the communication? You have made an RTI in 2023.
RTI, it is a communication, my lord, dated 24th May 2017, my lord.
That is not a communication. That is this list which has been furnished to you in 2023. Is this a communication?
Yes,
in the format?
Data vacancy, my lord. Submission of the.
When did you seek the
up-to-date data
information? When did you seek the information? You sought the information when?
My lord,
On 1/2/2023.
23, my lord.
Yes.
17/2/2023, my lord.
However, he submits. However, there was a litigation before in the court of the learned Munsif, Bilasipara, instituted by one unsuccessful candidate, which was registered at TS number 10 of 2023, 10 of 2013, along with Ms. J case number 9 of 2013. The petitioner states that an ex parte order of status quo was initially passed, which however the Miss case was dismissed on 29/6/2013, whereafter The audit interview was held on 10/7/2013. Full stop. The case of the petitioner is that after that, in the meantime, the SIU approval had left, and there was a communication from the inspector of school, Dhubri, dated 21/1/2014, to the director of secondary education, seeking extension of SIU approval. Three, para 3, Dr. General Counsel for the petitioner submits that a direction may be issued for grant of SIU approval so that the petitioner can be appointed. On the other hand, U. Sharma, standing counsel, secondary education department, has submitted that the SIU approval had left in the year 2014 itself, and this petition has been filed after more than 5 years. He accordingly submits that the petitioner may not be entitled to any equitable relief. We am here, the counsel appearing for the finance department, has endorsed the submission of Sri Sharma and has also submitted that on the ground of inordinate delay itself, the writ petition ought to be dismissed. This court, after hearing the parties, this court has noticed that cause of action, if any, had arisen in the year 2014. In the years 2013-14, and this petition has been instituted only on 6/9/2019. That is after about 5 years. There is no explanation for this inordinate delay in this writ petition. In a specific query regarding any communication in the meantime, the doctor has placed before this court certain documents which he had obtained under the RTI Act. Apart from the fact that these documents are not made part of the writ proceedings, a bare perusal of the same would reveal that certain information has been granted along with certain enclosures. The said enclosures, however, are are relating to vacancy positions.
27.
Vacancy position. This court is of the considered opinion that the power exercised under Article 226 of the Constitution of India is extraordinary in nature, where the conduct of the petitioner is of paramount importance. In the instant case, the petitioner has approached this court after a lapse of about 5 years without any explanation. Under the aforesaid facts and circumstances, this court is of the view that no equitable relief is entitled to by the petitioner, and accordingly, the recruitment shall dismiss.
In this case, my lord, we have challenged the advertisement issued by the Assam University teacher in respect of 6 numbers of posts where my lord, they have been reserved without following the due procedure. What happened during
They have what done what?
They have de-reserved.
De-reserved.
Without following the due procedure. My lord. On the ground, we have challenged this honorable court given the protection in the interim, and my lord, during the pendency of this writ petition, they have restored they have informed my client that they have restored the earlier position of the concerned post. In view of the above, my lord, this impugned advertisement is set aside, and in view of that, my lord, impugned advertisement may be set aside, and fresh direction may be issued for my lord, recruitment.
Heard the broadcast learn counsel for the petitioner. Also heard the ST Kyle learned counsel for the
What's if respondent number 2?
no, what university? This is Assam University.
Assam.
University. Whereas the A. Chamwa learned standing counsel UGC is also present. Yeah, for 4. And Mr. Sharma? U. Sharma secondary. Huh?
No, secondary is not a party.
Secondary is not a part.
State is not a party.
This is not a party. And respondent number 4, who are you? No, who are you?
Liaison officer.
SSD.
Yeah.
Dave. MSSD, respondent number 4. The grievance of the petitioner, which is an association, petitioners, out of which the petitioner number 1 is an association, is with regard to a recruitment process initiated by an advertisement dated
My lord, 3 advertisements.
by advertisements dated 6/8/19, 7/9/19 and 8/8/19. The principal ground of challenge is that post earmarked for reserve category have been de-reserved without following the due process of law. The forecaster, the learned counsel, has however fairly submitted that he has been instructed by his client that in the meantime, the policy of reservation has been withdrawn, and accordingly, he prays for a direction for issuing a fresh recruitment process, for initiating a fresh recruitment process by setting aside the earlier recruitment process initiated by the impugned advertisement. The aforesaid submission of Mr. Purkaster is endorsed by Sri Kyle, the learned counsel for the Assam University, and submit that the action, the decision for de-reserving has been revoked. You don't have much of a role?
No, I don't have it.
Yeah, okay. Sri A. Chamo and Standing Council, UGC, submit that it is up to the college authorities, university authorities, to take a decision for Kapara. MSS Dev, the learned counsel for the response number 4, however, by referring to the affidavit in opposition filed on 16/12/2022, has submitted that steps have been taken to revoke the decision. That the decision has been revoked and steps have been taken to prepare the roster point by following the reservation policy.
That has already been prepared. Lord.
Put the para. In view of the above, comma, Sri Kyle at this stage informed this court that the steps have already been taken and the
Roster has been prepared.
that the roster point program, roster point reservation has already been prepared, and the same would be acted upon. In view of the above, comma, there is hardly anything left to be adjudicated in this petition. Accordingly, the same stands allowed by directing that not required. We are not saying anything. Since allowed by directing, by setting aside the impugned advertisement, that is so and so, and in view of the
My lord,
in view of the admitted position that roster point has been prepared, comma, press recruitment may be initiated by following the due process of law.
Lord, in respect of 6 numbers of posts, it may be indicated because otherwise it will cover many other posts there in the advertisement. 6 numbers of posts I have indicated in the prayer procedure. That may be indicated.
In other lordship, already process is initiated.
For the reference concerning 6 numbers of posts.
6 numbers of
posts. Or as the board as the board the learned counsel further submit that the SPA number 4 has categorically stated that there was no lapse on his part.
Much of it.
problem.
This matter is already issue is already settled by this honorable court in several cases and division will place on
Already decided. Will then close this.
That would not mean now. And,
Doesn't matter if
Friday.
he's agreeing. What was the cause of action?
The petitioner's services lecture was denied on the ground of underqualified by the speaking order page 95.
Heard the pieces like counsel for the petitioner. Also heard three.
I am for reference number 1.
Also heard MS Leaders Government State Council as we are for higher education. We are for finance department. We are for finance department. Para. At the outset, this court has been informed that the issue involved has been resolved by this court. Para. the petitioners, the fact projected is that the petitioners were initially appointed in Venture College as lecturers pursuant to a selection process in the year 2000-2001. The petitioners claim to have possessed the requisite qualification of securing 55% or above in their master's degree. The the contention of the petitioner is that though the colleges where they were rendering services were granted government concurrence as well as affiliation, comma, the UGC had issued notification dated 24/12/1998 recommending minimum qualification for the post of lecturer, which has been redesignated as assistant professor. Full stop. In adopting the aforesaid guidelines, comma, certain conditions were imposed with regard to the requirement of net SLET and alleging discrimination, comma, this instead petition was filed. As indicated above, comma, the issue involved has been decided by this court by judgment dated. You give the judgment, okay? After some time,
Yes.
With this so and so passed in writ appeal,
Will check it out.
writ petition and double division bench
Single bench as well as division.
in the WPC so and so,
by
which has
three
also
judges.
been confirmed by the honorable division bench. In view of the above, comma, this litigation stands closed.
Okay.
You give the details to our court master. It will take, item number
22 minutes.
Yes.
Maybe.
Yes.
This matter, my lord, regarding my lord, regulation of service, my lord, petitioners appeared in the student before the student committee, my lord, for verification, and they submitted my lord working certificate, but they have been treated as no.
Yes, instructions.
Similar order is there, my lord. I have given my lord order, my lord.
After notice has come for the first time over.
My lord, it's come after a long time. My lord,
listed but left over, my lord.
it was a leftover, my lord. It has come.
You get the instructions first time it's been come, it has come up for consideration. Notice was issued on 8/11/19.
Similar order is
First
there,
time.
my lord. You can dispose of, my lord. I have given on.
Dharmajyoti Rekha,
20.
Yes, ma'am. Yes, ma'am.
Only
you take instructions on this.
I'll take instruction.
On Dharmajyoti, if it's covered, then we'll
I have also given.
we'll have it next week.
Next week, my lord.
Lordship can do one thing, Lordship can dispose it up by directing the.
No, we'll dispose of. You have a look at this.
My lord.
If it's covered, we'll dispose of
Then
today. We can have it on Friday
Right.
or Monday next, whenever you.
Monday, my lord.
Right.
Monday next. But you have a look at this.
I'll look at
You
it.
have a copy of Dharmajyoti.
I have it.
H.R. Ahmed, learned counsel for the petitioner submit that the issue would be covered by a decision of this court passed in WPC 8352/2019 within bracket Dharma Jyoti Deka and others versus State of Assam. Passed in rendered in distance rendered in para 3 8 Bukan learned standing counsel. This is second elementary education, elementary education. 6 sometime put the para list in the interest of justice list on
Lordship,
19
19.
put the aspect that the issue is covered by earlier decision would be considered under the list. The aspect as to whether the issue is covered. So how will what is this?
Regarding the selection of assistant headmaster, Amalgamated school, respondent private respondent selected violation of the memorandum lordship guideline as well as rule lordship. Kindly see first lordship, the office memorandum lordship, kindly page 21 lordship. Yes, prescribed regarding the selection and procedure of the assistant headmaster of the amalgamated school lordship. Page 21 and excerpt 4, this is office memorandum lordship 2016.
Let us know the facts.
Page 20.
First, let us know the facts.
Private respondent we are promoted as a assistant
Who are you?
headmaster lordship. I am the senior most teacher lordship of the amalgamated school.
Petition earlier.
Earlier, I am the Hindi teacher of a high school lordship, amalgamated senior most school lordship.
Your Hindi teacher
Of high school lordship.
of high school. Then name of the high school. What is,
One ME school.
what is the name of the high school?
Bhatta High School.
Bhatta.
Bhatta BS School, High School. In the district of Kamrup Rural.
Bhatta.
Bhatta
BS.
BS High School.
Okay. Then what happened?
In the year 2000, 2017 lordship, this school was amalgamated with another two school lordship, one ME school and
2017.
2000 by order dated 6/4/2017 lordship. Page 26 and excerpt 5 lordship, amalgamation order. Amalgamated with the Bhatta BS ME school and Bhatta MB.
MB.
Yes.
Yes.
By the amalgamation order lordship, let us take it 16/6/2017 lordship. There is a list lordship prepared by the authority concerned in this.
You said amalgamation order is 6/4/17.
Sorry lordship, 6 June 2017. This is reference letter lordship 6/4/2017.
It is amalgamation order 6/6.
6/6/2007.
Page
26 lordship and excerpt 5.
26. Yes. Yes.
Thereafter, lordship, as per guideline, existing headmaster of the high school lordship, he appointed as a headmaster of the state amalgamated school lordship.
Not 6, this is 16. Not 16, 16 June.
16 June lordship.
6 June you have sent it.
16 June.
16 June, 6/2017 amalgamation. Where are you?
Lordship, my name is serial number 3, HP Moheshwar Das.
Okay.
Headmaster Sharat Chandra Das, who is the existing headmaster of the state school lordship, high school.
Okay.
In the state list lordship, kindly next to it, the serial number 16, Sharat Chandra Kolita, AHM, right side written lordship as a AHM, assistant headmaster.
Yes.
Lordship. He is promoted as the assistant headmaster as per the guideline, Lordship. During the, after amalgamation, Lordship, what happened, this said, assistant headmaster Sharat Chandra Kolida retired, Lordship.
After the amalgamation.
After the amalgamation.
When did he retire?
He retired on he retired, Lordship, he retired, his date of retirement is 30/4/2017, Lordship. In the last page, Lordship, 30/4/2010, before amalgamation, Lordship. Does this section list
Retired. Okay, then
page 30, Lordship, is reflected his retirement date of
page
retirement.
30.
Page 30 and exact 6. This is the impugn loader we have taken, Lordship.
30, yes.
Yes. Moreover, the name of designated post as AHM in respect of Sharat Chandra Kolita as appears in column number 7 against serial number 6 in government letter dated so and so is hereby deleted as Sri Sharat Chandra Kolita retired on superannuation on 30/4/2017.
Okay.
So according to the guideline, Lordship, thereafter after his retirement is he already retired, Lordship, so assistant headmaster should be selected by the procedure of law, Lordship. There should be a selection. But by this order, annexure C is 30, Lordship. The respondent authority appoint the private respondent as a assistant headmaster.
Private respondent number?
Private respondent number 3, Lordship.
Mr. Gogoi's client.
Yes, Lordship.
Okay, welcome.
He retired into Agat. Retirement. Amalgamation. 27, Lordship, serial number 22. Private respondent name is appeared, Lordship, there. HM Horakanto there. His name is appeared serial number 22.
20,
So serial number 22, page 27, Lordship.
serial number 16.
27,
Serial number not 22, serial number 16.
page 16,
Okay, 22, Horokanto.
Horakanto.
Is Mr. Gogoi's client.
Yes, Lordship. Who is the
Respond number
respondent number 3, Lordship.
or 3.
There is office memorandum, Lordship, which is in applies for the selection of headmaster and assistant headmaster of the amalgamated school, Lordship. Page 21, annexure 4, this is the office memorandum, Lordship. Pursuant to this office memorandum, Lordship, amalgamation was done. Page 6, 21, Lordship.
21.
Annexure 4. Office memorandum dated 22nd September 2016, Lordship.
This governs amalgamation.
Amalgamation.
22nd of September.
September, Lordship. Next, page 22, Lordship. This is relevant part, Lordship. 22 page, column number 7, Lordship.
Serial 7.
Serial 7. In the event, the highest school is high school. The headmaster of the high school shall continue after amalgamation. The post of headmaster of ME school shall be redesignated as a assistant headmaster with same pay scale whatever they are drawing, and the post shall be held by the existing headmaster of ME school without requiring the qualification for the post of assistant headmaster. However, after creation of the service of such assistant headmaster, the vacancies shall be filled up from the candidates having requisite qualification as per procedure stipulated in the service rule in force. Lordship, so there is a ME headmaster of the ME school who is the serial number 16 in page number 27. He is promoted as a assistant headmaster, Lordship. But during the amalgamation, he retired, Lordship.
Page 27.
27, serial 16, Sarochandra Kolita. He is promoted as a assistant headmaster pursuant to this office memorandum, Lord. In his serial number right side, AHM is written, Lordship. There is shown AHM, assistant headmaster.
He was HM of the ME school.
ME school, Lordship. Accordingly, he was promoted as per this guideline, Lordship, as a assistant headmaster.
Okay.
But he could not join during the procedure of the amalgamation. He retired, Lordship, from the service. Till the amalgamation, there is no regular headmaster, Lordship, as he is retired already on.
But why in serial number 22?
Yes, Lordship.
So far as Horokanto Kumar
Horokanto
Deka is concerned.
He is the headmaster of MB school, not ME school. He is the MB school which was amalgamated with the high school, Lordship. But guideline says that headmaster of ME school will be promoted as a assistant headmaster of the amalgamated high school.
What about MB school?
MB school, Lordship, this guideline, Lordship, there is a clear in the post of headmaster of ME school shall be redesignated as assistant headmaster with same pay scale whatever they are drawing, and the post shall be held by the existing headmaster of the ME school without requiring the qualification for the post of assistant headmaster. Thereafter, they have not conducted any selection, Lordship.
No, what about ME? What is the difference between ME and MV?
This is, Lordship, in some secondary education provincialized school rules 2018, Lordship. Recruitment to the post of headmaster, assistant superintendent procedure thereof. There is a guideline, Lordship. ME, Lordship, only 3 classes, 5 to 7, Lordship.
MV?
MB 1 to 7. MB school, this is the difference. But in the guideline, headmaster of the MB school not mentioned, Lord. This is my case, Lordship, without going through any selection thereafter, Lordship. They have, by the impugned order, page 30, Annexure 6, they have promoted the private respondent as an assistant headmaster, Lordship.
This memorandum of at page 21 does not say anything about MV.
No, Lordship. In the rule, Lordship, there is a mentioned MB. But, Lordship, in case of amalgamated high school, the headmaster of ME or MB school is eligible for selection as an assistant headmaster, subject to the condition that the incumbent should have at least 5 years experience as a headmaster in ME school. If he is a founder headmaster and 10 years of experience as a headmaster in ME school, if he is not the founder headmaster of the ME school, if otherwise eligible. This is the procedure. Everywhere ME school mentioned, Lordship, no MB. If only high school and MB school amalgamated, then he may be promoted, designated as a assistant headmaster. But there is ME school also there in the same amalgamation order. And the teacher of high school, Lordship, senior most teacher of this high school. Lordship.
High school.
High school. So I may be allowed to participate in a selection. Lordship, there should be a selection regarding the appointment promotion with the headmaster, assistant headmaster. Lordship. Guideline clear, Lordship. After cessation of the service of such assistant headmaster, the vacancy shall be filled up from the candidates having requisite qualification as per procedure stipulated in the service rule in force. His appointed, his name was redesignated in 19 July 2019. But the amalgamation was in the year 2017 after 2 years. Existing assistant headmaster was retired on during the amalgamation.
Okay, yes, what do you say? Okay. First, yes, the department. This is for secondary education.
Yes, madam. As per clause 7, my lord, the post of headmaster of ME school shall be redesignated as assistant headmaster with same pay scale, whatever they are drawing, and the post shall be held by the existing headmaster of the ME school without requiring the qualification of the post of assistant headmaster. However, after cessation of the service of such assistant headmaster, the vacancy shall be filled up from the candidate having requisite qualification as per procedure stipulated in the service rule in full.
Yes.
The petitioner, he was his contention that the petitioner being eligible to be appointed as Hindi teacher of a high school, my lord. And the director of secondary education appointed as senior Hindi teacher against the Hindi post created by the government.
Katani have not prepared the brief. What are you submitting?
In fact,
this is a controversy of Hindi teacher.
No, my lord. This is regarding my lord, assistant.
What is the point involved?
In fact, my lord, I have just now,
Then don't appear.
I have just.
Why did you take the responsibility to appear, stand up before this court? If you have not prepared with the brief.
I'm otherwise, I'm sorry, my lord, but just now I have come to know that this is secondary matter, my lord. In fact, I am
You
outside.
seek time, we'll grant you time. Don't prepare a case in front of the court without knowing even the issue.
Yes,
And what is there to prepare?
I'm sorry, my lord. I'm sorry.
You have heard your colleague.
Yes, my lord.
What is the point involved?
Just now I have come, my lord. In fact, in the first session, I was absent, my lord. I've been.
Okay, we'll hear you. You go through the brief.
Yes, my lord.
Point involved is the OM talks about an ME teacher, the status of an ME teacher who was the headmaster of an ME school. What will be his status after the amalgamation? It doesn't say anything about MV, the headmaster of an MV school. Here, 3 schools are involved.
Yes.
Now, the headmaster of the ME school, he had retired before the amalgamation was done. So it has been corrected that the incumbent who was holding the post of headmaster in the MV school, he has been given the charge of the assistant headmaster of the amalgamated school. His contention is that that post has to be filled up by regular recruitment, where he gets a chance. You prepared that is the only
My lord,
point.
give me some time.
You will hear Mr. Gogoi.
Yes, my lord. In the meantime, I will.
Yes.
By the amalgamation, Lordship, by amalgamation order dated Lordship 1676 2016 Lordship, 3 schools has been amalgamated.
Page.
Yes, Lordship.
27.
Lordship.
27, isn't it? Or 26? What? 26. 26. Annexure 5.
Lordship, Lordship में take the office member, Lordship.
The
Annexure 4, Lordship.
governing amalgamation.
Office memorandum dated 22.
Yes, this is governing amalgamation. Yes, page 21.
Here, Lordship, although as per the clause 7, the MB school has not been mentioned, but both are upper primary school. MB school and MB school, both are upper primary school.
From where do you make this contention?
Lordship, actually, if we go to the Lordship definition part of the upper primary school and the elementary education provisionalization rules to 1977.
Just a minute. You're carrying which book? This book? No.
Some elementary education provincialization rules 1977 also.
Yes.
But if we go to the definition part, at
just a minute. Just a minute.
Sorry.
$293. Yes.
Lordship,
Definition.
Definition. Upper primary school.
Two?
12.
212.
212.
Rule 212. Right. 212. Yes.
Upper primary school means institution imparting education up to class 8, including ME school or MV school, or ME madrasa or senior basic school, individually or a combination of any 2 or 3 of all 4 categories of this institution.
Yes.
Lordship, ME school, in ME school, it is class from 6 to 8.
ME.
ME.
Yes.
And MV school is class 1 to 8.
Okay.
Both schools are same, Lordship. And recruitment process of the headmaster is also same. And the pay scale also same. Headmaster, Lordship. Lordship, if we
Yes.
If we go to the Assam Elementary Education Provincialization Service and Conduct Rules 1981.
81 rule.
Lordship. Assam Elementary Education Provincialization Service and Conduct Rules.
Yes.
Lordship. If we go to Schedule 2, Lordship.
Schedule?
Schedule 2, Lordship.
Yes. Schedule 2.
Schedule 2. Lordship. If we go to the pay scale of teachers of elementary school, Lordship, then headmaster, MV, senior basic school, Lordship, it is the same.
Yes.
And Lordship, in the scheme, Lordship, although it has not been mentioned as MV school, Lordship, if we go to the clause 11,
11.
Lordship, it is
Into if 2 or more UP, upper primary.
if 2 or more UP, ME school. Lordship. Lordship, although there it has not been specifically mentioned about the MV school, if we go to the Lordship 2018 rules, Lordship, Assam Secondary Education Provincialization School Service Rule 2018. Assam Secondary Education. It's Lordship here section 28. Lordship, sorry.
You are referring to the 18 rule. Which section? Which rule?
28, Lordship.
Rule 20.
28.
28.
Lordship.
Yes, please.
Lordship. May I read, Lordship? One, under Shiksha Kshetra scheme for amalgamation and merger of schools, the schools situated in same campus or in any nearby area may be amalgamated, merged, and all the schools are brought into one single administrative and academic unit. And here, subsection 2 for rule 2, in case LP or ME oblique MV school or both are amalgamated with a high school, all the teachers and other staff of the LP or ME for both schools shall be employee of the amalgamated school, and their services shall be disposal of the secondary education department. The headmaster of the high school shall continue after amalgamation. The post of headmaster of ME school shall be re-designated as assistant headmaster with the same pay scale to be held by existing headmaster of the ME MD school without requiring qualification for the post of assistant headmaster. After cessation of the service of the incumbent of the post of such assistant headmaster, the vacancy shall be filled up as per normal procedure stipulated in the service rule. The staff pattern shall be fixed as per existing norms for a high school, and active teaching and non-teaching employee shall be posted elsewhere against the vacant post with their seniority of the earlier school. Then, Lordship, 3.
3 is higher secondary.
High secondary.
This 28(2) is almost perimeter with clause 7. And only the word MV appears here.
ME and MV. ME and MV. Next. If a high school, may I read, Lordship?
3 is not required, it's a higher secondary.
High secondary. If in the high secondary a headmaster of the ME and MB school can be a vice principal, then in the high school he can be assistant headmaster. Maybe here it is not mentioned.
Yes.
Lordship, I've been appointed as a graduate teacher, Lordship. I've been appointed as a graduate teacher. And initially I was appointed in the ME school as a graduate teacher. Then in 2014, I've been promoted as a headmaster of an MB.
Your response number?
3.
When are you promoted?
Lordship, my promotion order, Lordship, will find it is my affidavit, Lordship.
Date.
Date, Lordship, 25/10/2004.
2004, you were promoted as principal of
Headmaster
as headmaster of the MV school.
MB school. Bakta MB school. Then, Lordship, initially, this as part of the scheme, though I've been wholly charged of the assistant headmaster, as part of the scheme, I have been not granted any extra. I have been not allowed to draw the pay scale of the assistant headmaster.
Why?
As part of the scheme, Lordship. It is as part of the scheme. But subsequently, Lordship, now Lordship will find at page 28 of my affidavit in opposition, and extra is as I have the required qualification for the assistant headmaster of the high school, I've been allowed to draw extra, the grade pay of the assistant headmaster of high school, along with some other eligible assistant headmaster.
From date of amalgamation.
Lordship.
Okay.
Lordship, in the list, Lordship, name of the incumbent come from the MB school, come from the ME school. It's not that from ME school, then headmaster has been selected. So far as the impugn Lordship order, this is the only Oregon Lordship. Actually, as on the date of the amalgamation, Lordship, my name should be reflected in that amalgamation list, Lordship, because the person who has been shown as assistant headmaster, he has already retired. He is retired on April 2017, and amalgamation was given on June 2017.
June 2017.
Okay.
Now, what has happened after in April, 30th of April 2017, Sarat Chandra Kolita has retired as the headmaster of the ME school. What happened to the post of headmaster of the ME school prior to the amalgamation?
That was probably not filled up. Citizen post would be filled up by regular selection process.
So at that time when the actual amalgamation took place,
Lordship,
ME school was without a headmaster and MV school had a headmaster in.
and because probably why he said name has been forwarded the headmaster of the ME school. It probably just party scheme the senior most headmaster will be recommended.
Now, in a given case, where three schools like the present case are involved, one ME, one MV, and one high school. ME and MV schools gets merged with the high school. Now, high school, the headmaster continues in the same capacity. As headmaster, the headmaster of the ME school becomes. What will be the position of the headmaster of the MV school? Here is a unique case. You say that at the time of actual amalgamation, there was no headmaster in the ME school. So you were given considered for the post. That is your case. Now, if Sarat Chandra Kolita was in his service, then what would have happened? Who amongst you? You or Sarat Kolita? How do you select? If your contention is that ME and MV are to be taken at par, then you are also a contender. Sarat Chandra Kolita is also a contender. Assuming that he was still in service, 2 more years of service left. And who gets this hand?
The senior most headmaster.
Senior most, either of the ME or MV.
Guideline says the headmaster of ME school.
Who will come back?
Logic may kindly logically go to the scheme of 4 logic.
Of the scheme?
Scheme, okay.
4.
4. After
Yes. In case.
logic four logic in page number logic.
Page 22.
In my applicable logic 43, page number 43. But it may probably research P4 logic, but it is only 4 logic.
Your affidavit.
Order the following logic in my affidavit. Page 43. Page number 13 of 43, running page.
And your page? 13. 13, yes. Clause?
4, clause 1.
What is this?
Further, the following shall be conditions of the school, including the service
2nd
condition
September.
of the March. Okay.
Same notification.
Also here, it is written that the senior most headmaster shall be the headmaster of the school after March. So the date
September
analogy has been
1996. Your which
4
4
1.
the school having good infrastructure.
With amiable academic atmosphere and good features in comparison to other schools shall be best school, and other schools shall be marked
Just a
with
minute,
their
just a
school.
minute. Just a minute. Four One.
One.
Yes. Yes, please read.
The school having good infrastructure facilities together with amiable academic atmosphere and good teachers in comparison to other schools shall be best school, and other school shall be merged with that school. The senior most headmaster shall be the headmaster of the school after merge. For the that analysis has been brought into.
Yes. Yes.
Okay.
Yes, Mr. Khatani.
Admittedly, my lord, during the time of amalgamation, my lord, there was no headmaster in the ME school, my lord. This is the pleaded case of the
In the ME school.
ME school, my lord. And in the MB school, rest number 3 was, he was acting as a headmaster, my lord.
Not
So-
acting. He was the headmaster.
Yes, my lord. He was the headmaster, my lord.
No HM in ME
Yes, my lord.
at time of.
Paragraph 8 and 9, my lord,
Yes, yes.
of the writ petition.
Mm.
So as per the scheme, my lord, as per clause 7, since
3-7.
7, my lord, since the headmaster of the MB school, rest number 3, so he was appointed as the assistant headmaster, my lord, for amalgamation.
No, his contention is that when there is no mention about MV,
Yes, my lord.
can you incorporate the headmaster of an MV school
But
to be the assistant headmaster? His contention is that his chances of being of being considered for the post of assistant headmaster gets ameliorated because there will be no direct recruitment now.
Yes, ma'am.
Till Mr. Gogoi's client is holding the post.
Yes, ma'am.
It is only after his retirement that he gets a chance.
Yes, ma'am.
So there is a cause of action.
Yes.
So how do you, what is your stand?
My lord, since there are 2 schools are amalgamated, my lord.
3 schools.
3 schools are amalgamated. 2 schools are with the high school, my lord. Since as per scheme, though there is no mention about the MB school, but otherwise the status is same, my lord, ME and MB. That is why, my lord, as per, since in MB school there is a headmaster, that is why, my lord, he has been appointed as assistant headmaster, my lord.
Now, are you, will you agree with the submission of Mr. Gogoi that
There is
in a given case where headmasters of both the ME and MV are existing,
Yes.
unlike this case, and both the schools are merged with a high school,
Yes.
then who will be the assistant headmaster? Is it the senior most headmaster among the ME and MV?
Clause 4, my lord, page 23. Here it has been mentioned, my lord, the senior most headmaster shall be the headmaster of the school after March.
Clause?
Page 23. Page
Yes.
23 of the writ, my lord.
Yes. Clause?
Clause 1. Further, the following shall be the condition of school, including the service
23,
condition
clause
of the employees after
4-1.
Yes, my lord.
4-1 over.
Yes, 4-1, my lord.
Yes.
4-1.
Please read.
The school having good infrastructure facilities together with amiable academic atmosphere and good teacher in comparison to other schools shall be base school, and other schools shall be merged with that school. The senior most headmaster shall be the headmaster of the school after merge. So, my lord,
No, this is merger of 2 ME or 2 MV.
yes, my lord.
In that case, we understand that the senior most will get a chance.
Yes.
Now, when these 2 schools, it's not a merging, they are being amalgamated with one third school, high school. So the question of headmaster is not in conflict. The headmaster of the high school remains the headmaster.
Yes.
The question is who will be the assistant headmaster?
Yes.
Whether it will be the headmaster of the ME school or the headmaster of the ME school.
Yes. Yes, my lord. In here, we have not filed any affidavit disclosing our stand, my lord. May I pray for some time, my lord, regarding this? Why did
No, but this will interpret.
what procedure they
No, he has also relied upon certain sections to give an idea.
that MB and ME
are almost at par.
Otherwise, at par, my lord.
Recruitment process is at par.
My lord may take it at 2, my lord. I can obtain a telephonic instruction.
Okay,
What procedure they
Okay, we'll have it at 2.
at 2, my lord?
We'll have it at 2. Only for your that part?
Yes, my lord.
Yes. Anything else?
No, my lord.
Yes. Anything?
No,
Take 5 minutes for your rejoinder if you want.
no, no, no.
We come back at 2 o'clock.
Yes,
okay? He also goes by the statutory provisions.
Yes, my lord.
You may have something. Because the act in question, the statute in question, utilizes the word MV also.
Yes.
Whereas in the OM, that MV has been left
ME,
out.
Only ME.
Is it left out consciously or by inadvertence?
Yes, my lord.
When the statutory provision contains that provision, MV, I think it should be read into.
Yes, sir.
We are just thinking aloud.
Yes,
You cannot segregate MV and leave the teachers
otherwise,
high and dry.
otherwise at par, my lord.
Because that provision which Mr. Gogoi has relied, namely was it Rule 28 of the rules of 2018? Rule 28, I think,
Yes, ma'am. Page 44.
of the rule.
2018.
I think the same provision which has been relied upon, namely 3.7, that is also there, isn't it?
Yes, ma'am.
Just having a look. In fact, Rule 28 is almost the scheme OM of which has been relied upon.
Yes, ma'am.
That is this Rule 28 only.
Yes, ma'am. The OM came into force in 2016 and rule is subsequent to that, my lord.
That is it. But
Yes.
rules, it has taken a statutory color after the rule.
Yes, my lord.
And here in the rule, MV has been inserted.
Yes. Maybe it was inadvertent in the 2016 OM, my lord.
In the OM.
Yes, ma'am.
Look into this aspect also.
Yes, ma'am.
How you also look into aspect. Let's have a look. We want to come to a fair conclusion, irrespective of which side we decide. Okay. At 2 o'clock.
Yes, ma'am.
Lordship, in these matters, Lordship, we are filing an affidavit, Lordship. What has happened is, in the first case, Lordship, out of 167 people, 146 have been not approved, Lordship. That we are bringing in on affidavit because there are so many petitioners. So some time may be given, my lord. In the first case, just one information I have that one
It
out
is a
of
19 matter. How much time do you need?
10 days, Lordship, 10 days. 10 days will be given because there are so many petitioners, my lord. In the first case, there are 67. Second
We'll
case,
grant you 10 days, but you file your affidavit.
We've already it's
Because 19 matter, we don't like to delay this kind of.
We've already prepared. We have sent it, man.
Okay.
Lord, earlier occasion also take time as this is a voluminous last chance may be given.
Okay.
Voluminous.
My lord.
3A, heard 3, we are learned concept for the petitioners. There are three A Fukan learned training concept. This is for secondary education, elementary education.
Elementary.
However, submit that the affidavit is under preparation and can be filed shortly and would be filed shortly. He accordingly pays for and is granted 10 days time to file the same.
But may I pray for a date, my lord?
Hello.
Lord, on June 27th. Can be.
Yes, 27, that part will be difficult. We'll try 27 June.
Mal.
Deeply.
Bless.
29 also same, my lord.
Same, 29.
29, same. You have filed affidavit in 29.
No.
There also, my lord, it's in preparation. And the third case, I think, one of the BTC is required, not us. First two cases, we are the.
BTC, anybody?
First
You inform BTC
we'll
that
inform,
we are
we'll-
fixing together.
Together, right? It's with only, analog.
Petition has not been tagged in the record. So, my
You-
lord,
You had filed amended petition.
amended petition 1 month ago. We had filed.
Amendment also allowed by my lord, already allowed the amendment petition also.
When did you file?
My lord, on 15th May. 15 May we have filed.
आणि ভালো সাইজ অফিসিয়াল আছে না
হ্যাঁ
অফিসিয়াল আছে না
Till 18.5 it was not received. Till 18.5 office note says that it was not received by the office.
My lord, 119, the second has received the same 119.
My lord, copy has been served to all, my lord.
Sri A.R. Sikdar, learned counsel for the petitioner, submits that a consolidated writ petition has been filed pursuant to an order dated or an order passed by this court allowing such amendment. Sri Gogoi, the learned technical higher education, and Sri Azad, learned counsel for responsibility 8 and 9,
I'm for 10.
as well as Sri P.J. Fukan, learned counsel for whom? What university?
No, my lord.
Private respondent.
For respondent number 10, private respondent number 10 have acknowledged receipt of such. You have received the copies?
We have received, Lord.
Have acknowledged receipt of such amended writ petition. The state, the amended writ petition, which however is not tagged with the record, list after a week along with the amended writ petition.
My lord, maybe after vacation.
No, my lord, I have to come here in doing interim order, my lord.
After list on today 14, list on 19th.
My
Here, my lord, ME and MV is considered to be in the same step of my lord, because the highest class is class 8, my lord, in the board stream, my lord, section, my lord. So, in case of if the both ME and MV is amalgamated with high school, my lord, in that case, the seniority of the concerned headmaster.
In fact, MV has a more responsibility.
Yes, my lord, because
class 1 to class 8.
1 to 8, and in ME
is only 6
to 8, my lord. His highest class is 8, my lord, and status is same. Pay scale is also same. In fact, in amalgamated school also, their pay scale are same, my lord. They are getting same pay. Only the senior most headmaster has been designated as assistant headmaster, my lord.
In the high school.
In the high school, my lord. This is the only difference, my lord.
What? Huh? Petition dated, petition custom code. Sarina reserve of the certain of the we'll do one thing. We'll not detain the advocate. We'll pass the order today in the court itself. At 3:30, we'll dictate the order. Till that time, whatever is possible, we'll complete. Even if you're not present, doesn't matter.
May please, Your Lordship. In this case, I challenge the appointment of in-charge headmaster, my lord. That was earlier challenge was under the rule 2003, my lord. So now, my lord, 2018 rule come, my lord. He still continuing the post of in-charge headmaster. So now, my lord, earlier that in-charge seniority of school-wise was considered, my lord. So now district-wise seniority will consider according to eligibility norm as set forth in the. So my prayer, my lord, let the process has already, my lord, the government advocate will apprise the court. I came to know, my lord, it is already started within 15 days. All the schools are directed to give the list of the eligible teachers. So, my lord, my prayer, my lord, let the post be filled up according to new law, my lord. And till then, my lord, he will continue, my lord.
Yes, my lord. But my lord, there's an interim order, my lord. In this
Interim
case,
order was there, my lord.
my lord, it's very regular. You are holding as an in-charge.
Because of
My order
interim
is under
order,
challenge.
and he will not also got, I will not also getting chance, my lord. If the process, new process come.
I was allowed by order dated 22/8/2019. And this order is
Page
under challenge.
44, my lord, is there.
Okay. Third, Sri Goswami, learned counsel for the petition. Also heard Sri N.J. Khatonier, learned training counsel, elementary education. Secondary education department. Whereas Sri R.M. Dekka has appeared for response number 4. Number 4. Full stop. Considering the facts and circumstances of the matter and as agreed to by the learned counsel for the parties, this petition, which is pending since the year 2019, is taken up for disposal at the admission stage. The petitioner claims to be the senior most graduate teacher possessing MA and BA and therefore eligible to be considered for appointment to the post of headmaster of any high school. The case of the petitioner is that the post of headmaster of the Tarun Ram Phukan High School is lying vacant since the year since 31/8/2019.
Yes, my lord. Page
When
44.
the earlier incumbent had retired on attaining the age of superannuation.
Yes, my lord.
The aforesaid school aforesaid school no in para in when was it done? In 2018.
Yes, my lord.
School was
Amalgamated.
amalgamated in 22/11/2017, my lord. In the year 2018, the Tarun Ram Hindi LP School and the Tarun Ram Phukan Hindi LP School and the Tarun Ram Phukan Hindi ME School were amalgamated
on 22nd/8/19. synopsis, my lord, or
uh,
it is there.
were amalgamated with the Tarunram Pukan Hindi High School. Full stop. The case of the petitioner is that after such amalgamation and on creation of the vacancy, creation on 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 the vacancy having arisen, comma, the respondent number 4 has been allowed to hold charge of the headmaster of the high school. Full stop. The petitioner alleges that there has been violation of rules of violation of the Assam of the provisions of Assam secondary education within bracket provincialization bracket close service rules 2003, and therefore the instant petition has been filed with a prayer to interfere with such in charge arrangement so that the petitioner is also considered for appointment to the post of headmaster. Full stop. Para. Sri Goswami, the learned counsel, however, kindly submit that in the meantime, comma, the aforesaid rules of 2003 have been replaced by the
Assam secondary education provincialized schools service rule 2018.
2018. Full stop. He accordingly has modified his prayer by submitting that
As per rule 14, my lord, indicate.
by submitting that as per the present rule holding the governing the field, comma, a recruitment process be initiated in which the petitioner and all other candidates may be considered in accordance with law. Full stop. Para. The attorney at the learned standing council of the department does not object in principle to the proposition advanced, no, to the modified relief prayed for by the petitioner. Full stop. Para. Sri Dekha, the learned counsel for the respondent number 4 also does not object to the said to the relief presently prayed for. Full stop. However, he submits that by virtue of an interim order, he is continuing. You are continuing.
By virtue of the interim order, the regular appointment has been stayed.
By virtue of an interim order, comma, regular appointment to the post of principal has been stayed, which is benefiting neither the petitioner nor the respondent 4, and therefore the said aspect may be clarified. Put the para. In view of the aforesaid facts and circumstances, comma, the present petition is disposed of by vacating the interim order dated
2/12/19
and with a further direction to the authorities to initiate and complete a process for appointment to the post of principal of the so-and-so school, high school, in terms of the rules of 2018.
Till then, my lord, I may be allowed to continue the interest. In terms of the order dated 20.
The present arrangement by which the respondent number 4 was allowed to continue as in charge principal would, however, continue till such process as directed over is finalized.
My only thing is that, my lord, because of the rivalry, my lord, the name of my name was not shown while the name was, my lord, sought for by the IAS. That, my lord, petitioner's name and along with other eligible teacher, if any, all the names may be sent to the
it is further clarified that in the process which has been directed to be initiated for regular appointment to the post of principal or headmaster of the school in question, comma, the the all the candidates who are eligible.
Yes.
The details of all the candidates who are eligible shall be forwarded by school authority.
Obliged.
Deeply obliged.
Here, my lord, except petitioner number 6, my lord, all are absorbed, my lord, as a tutor. My lord.
Where is Mr. Ahmed? HR Ahmed. None appears for the petitioner on call. Sri P.K. Bora, learned counsel for the department, however, submits that out of the 6 petitioners, except one, the others have been appointed as tutors, and therefore there may not be any cause of action for Sapera. List on Friday. In the interest of the list on Friday next. Apply. Friday date.
May please be told. Although the matter regarding non-payment of arrear and current salary matter. Petitioners were appointed on 9/11/1998, and thereafter, my lord, they received regular pay scale, my lord, up to February 2012.
Yes, these matters were directed to be segregated, so it comes separately. Any instructions you have?
Here also, my lord, this petitioner has absorbed, my lord.
Absorbed?
My lord.
Mr. Roy?
Yes, my lord, they have been accommodated, my lord, as assistant teachers with prospective effect from 1/11/2020, my lord. They are receiving the current salary, my lord, but area salary remains unpaid, my lord.
On the condition that they will not claim the past benefit. My lord.
So that is without any other alternative, they have.
But you have to challenge that.
Yes, ma'am.
Once you have accepted that, until and unless you challenge anyway, accept your challenge, that condition will remain. We grant you liberty.
Yes, ma'am.
Sri D.K. Roy, heard to D.K. Roy, learned counsel for the petition. Para, also heard, no para naikali, also heard. Sri P.K. Bora, learned standing counsel, comma. This is elementary education department. The instant writ petition was filed has been filed for a direction for release of their current as well as arrear salaries from March 2012. The case of the petitioner is that after their appointment pursuant to an advertisement dated 1997, the salaries were stopped since March 2012, and therefore some of the similarly situated persons had approached this court by filing WPC 1764/2014, whereby a direction was given by this court on 12/5/2014, directing a verification by a screening committee. The petitioners contend that their cases were found to be genuine by the screening committee, in spite of which salaries have not been paid. Sri Bora, the learned standing counsel of the department, however, submits that the petitioners have been given fresh appointment a condition that they will not make claim with regard to any previous service. The said proposition, the said question, the said fact has not been denied by Sri Roy. Under those conditions, this court is of the opinion that unless any conditions imposed in the press appointment letter, which was accepted by the petitioner, is not put to challenge, the presented petition may not be maintained. In view of the above, the petition, Sri Roy, the counsel submits that he may be allowed to withdraw this petition with a liberty to challenge any conditions which has been imposed along with the press letter of appointment. Letter, the petition accordingly stands dismissed on withdrawal with liberty as straightforward.
Lordship, kindly pass over the matter for timing.
Timing at 2:30.
My senior is on another court.
What is the matter about?
Regarding the content, regarding again will the illegal and irregular appointee, my lord. In fact, here, my lord, the petitioners, and other one, my lord, they have been accommodated as tutor, my lord.
Now,
they have accepted their appointment, my lord.
yes, madam. Same like the other case. Just now we have heard.
Yes, my lord.
Madam, what do you say on the submission?
Lordship, give me 5 minutes. I will call my senior.
Who is your senior?
And my mama.
On Friday?
Yes, madam.
16 matter, no, not on Friday. We'll have it after some time. Call is senior. 16 matter, we're not going to adjourn.
Obliged.
Yes. 30 years.
The contempt petition, my lord. See, my lord.
So he says that in the meantime, some development has taken place. You have been appointed as tutor.
So there is a court order. My lord, that in the filing in review, my lord. Number one. Secondly,
The contempt, we are on willful and deliberate disobedience.
my lord, they file an affidavit. They stated, my lord, if honorable could permit me, my lord. They say that they paid the entire amount, my lord, para 5 of the affidavit in opposition. Filed by the respondent number 2, my lord. The director. My lord, they say that paragraph 5, my lord. That on completion of the verification process and on basis of the report submitted and on the basis of hearing apostate, the report was submitted government for taking necessary action in the matter by communication. So a proposal for payment of area salary and current salary with effect on so and so has been forwarded to the government of Assam. That is so and so for accord necessary sanction by creation of supernumerary post for the apostate period. And response number 1, therefore file an affidavit, my lord. They stated that, my lord, paragraph, my lord, page 3, my lord. Page 3, my lord. The deponent states in compliance to honorable court order dated government has called for the proposal for payment of area salary of the petitioner. I order dated 29/6/2000. Accordingly, the Director of Heidi's letter number was submitted necessary proposal to the government for accordingly the necessary sanction. The deponent humbly said that payment of area salary would be made within the next 4 months, my lord. My lord, till today they did not pay, my lord. There is a specific direction, my lord. My lord, they did not, when they also proposal and this also says that, my lord, they are going to comply with the honorable court order. Now my lord, as per instruction, my lord, they called the huge gathering in the Kanapura field. They distributed some appointment letter as a tutor. But we are in a sanction post. We are receiving in salary from the set of joining. There is a service book. Now they given only 10,000 rupees. Now they did not, at that moment of time when we in Kanapara, we have no any objection raised before the, because of the cannot manner. And we have no any bargaining power manner. There is a Supreme Court judgment also manner. The employer has given something, but we are in lower grade post.
Now you can challenge in the court if you want.
Well, they say that they are going to pay. They did not pay. But what about in the court order? There is a specific order of the honorable court. That honorable court
You
direct
take
order.
instructions from your client. Are you serious in pursuing this contempt petition?
My lord, at least they can go. They can
See,
pay
we have
the,
again told,
they can pay the area, my lord. And if they can, suppose they can give the test to file and review, my lord. My lord.
no,
If
Mr.
they can
Bora,
be
Mr.
not
Bora, we cannot pass further directions for payment. We can proceed with against them for contempt.
My lord.
That is the only thing remaining. We can proceed against them in contempt.
My lord.
Which they may lead to some penalty, may not. That's a different matter.
My lord.
But we cannot reiterate an order of the court. It is already been given, unless that is.
My understanding is that without review, my lord cannot. There is a court is the high power, man.
We are not on that.
Court cannot.
If you proceed
Court
on
was
the
not directed to give the tutor, man.
no, if you want to proceed, you take instruction and proceed.
Yes, my lord, I'm taking instruction.
You have taken instruction.
Yes.
You want to proceed.
Yes, ma'am.
Yes.
But pursuant to this order, my lord, there is a fact-finding inquiry, my lord. In that fact-finding inquiry, they have participated, my lord. After that, my lord, they have been identified as illegal picture, my lord. But government took a cabinet decision since.
Well, have you put those on record?
No, my lord. Because since they have accepted the appointment order, my lord, that instruction I have, my lord. If regarding this fact-finding inquiry, I have to put in on record, my lord.
No, what was the order of this court?
Yes.
Is the order at page 10?
Yes, my lord. Page 11, my lord. As there is no dispute that petitioner have been rendering service to the school till now, their case are squarely governed by the decision in the appeals referred earlier. Under the circumstances, the writ petition is disposed of by directing the respondent authority to pay salary of the petitioner from the month of September 2007 within a period of 4 months from the date of receipt of the order and after necessary verification. After necessary verification, their proposal gives the proposal to the authority. There is a specific direction. Without, my lord, my understanding, my lord, without, my lord, review or.
No. See, under these circumstances, writ petition is disposed of by directing the respondent to pay the salaries till they within a period of 4 months of receipt after necessary verification.
Order after necessary verification.
They were given a window to verify.
But as my affidavit is different.
Where is the affidavit?
Affidavit is stated by the director, my lord.
Yes.
Paragraph 5, my lord.
Paragraph 5?
My humble understanding, paragraph 5. That may I read, my lord. Paragraph page 2, my lord.
Not by the director, commissioner.
No, this is director first. That it is stated that on completion of the verification process.
Paragraph?
And on paragraph 5, my lord. And on the basis of the report submitted on the basis of hearing of as aforesaid, the report was submitted to the government for taking necessary action in the matter by communication dated 5/8/2016, and a proposal for payment of arrears salary and current salary with effect from 1/9/2007 to 29/2/2016 and from 1/3/2016 to 13/9/2016 has been forwarded to the government by communication dated 13/9/2016 for a record of necessary sanction by creation of a supernumerary post for the aforesaid record. They cannot now send differently. And thereafter, my lord, Commissioner, my lord, affidavit, my lord. Paragraph 4, my lord. May I read, my lord? That in compliance to the Honorable Court's order, the deponent has taken steps and relevant case records have been examined. In this regard, the deponent states that there are large number of teachers who are similarly situated and department is endeavored to release the area salary all such teachers after due verification. Moreover, due to Model Code of Conduct being in force since February 2016, because of election of Assam Assembly, the regular budget could not be introduced in the Assembly in the month of March 2016. And instead the budget was placed before the Assembly only on so and so. The deponent states that in compliance with the Honorable Court's order, the government has called for the proposal for payment of area salary of the petitioner by letter dated so and so. And accordingly, the director by letter dated 39/2016 submitted the necessary proposal to the government for according necessary sanction. The deponent humbly states that payment of area salary would be made within the next 4 months. There's a specific environment there. Now they are going to take in different step. My humble understanding that it is not. That is a affidavit filed in the year 2016. But the verification started for the entire state in 2012, pursuant to an advertisement, pursuant to the direction of this Honorable Court, my lord. In that verification, my lord, they have participated. 5 screening committee was constituted, my lord, for Upper Assam, Lower Assam, Middle Assam, and Borakvili and my lord, PTAD area. In that verification, they have participated, my lord. Thereafter, 4 category of teachers were identified. One is, my lord, recommended by the state level, state sub-divisional level selection committee.
This verification exercise was done when?
It was, hearing was conducted during the year 2014 to 16, my lord, for the entire state. Then report was submitted in the year 2000, first part of 17, my lord, 18. And to the, in the...
Then why was this 10 taken in both the affidavits? Both by the director and the commissioner?
Yes, my lord. That is, they have filed in the year 2016, my lord. While that an entire screening process was going on, during that time that this affidavit was filed by the director, my lord.
What you are submitting now,
yes, my lord,
that has not been stated in the affidavit.
No, that is a subsequent development. In fact, that is a subsequent development because this entire exercise was carried down from the year 2018, collecting the report from the divisional commissioner. Thereafter, in the year 2020, they took a decision to accommodate all the illegal and irregular employees who were appointed during the year 1989 to 2001. That policy decision was taken, my lord.
To file a detailed affidavit?
Yes, my lord.
But if he is serious on the contempt, we will have to proceed.
Yes, my lord.
Third free and Bora, Learned Counsel for the petitioner. Also heard free N.J. Khatanier, Learned Counsel for the respondent. Sri Bora has referred to the affidavit filed by the respondent, from which it appears that steps were taken for compliance of the order in question, in spite of which the arrears salaries have not been paid. On the other hand, Sri Khatanier, Learned Counsel for the respondent, has submitted that though certain statements were made in the affidavit, a detailed verification was made thereafter, in which process, the petitioners had participated, wherein it was revealed that the initial appointments were not legally done. However, a policy decision has been taken to absorb all such employees, public teachers, in the service by appointing them as tutor, which has already been done. These facts may be relevant in the adjudication of this case and are required to be put on affidavit, which has not been done till date. Under those circumstances, this court grants
10 days time.
2 weeks time to Sri Khatuniya to file the affidavit incorporating all the details as mentioned above.
Obliged, Lord.
Yes.
Absolutely.
This is against non-compliance of the order dated 28/4/2016 matter passed in WBC 61/2011. The review was also referred by the important and the review was received on 14th of March of this year. Now,
In the meantime, my lord, the incumbents have already retired. Perhaps, my lord, I have already, my lord, given the name of the new commissioner and secretary. The present incumbent. I have, he need to be, my lord, implemented here.
What was the direction?
the repetition was allowed and we are now entitled for his death of retirement benefit period.
You are the family members or retired employees
Retired employee.
of
They are retired employees of
they represent an association, my lord, concerning all the retired employees of the state of Assam. Government of Assam, my lord, took a decision, my lord, thereby fixing a cut-off date, my lord, for granting
retired officers, teachers.
Yes. Now, my lord, in the year 2011, my lord, the government of Assam, my lord, took a decision. That was a policy decision, my lord, whereby, my lord, a cut-off date was fixed for, my lord, granting notional benefit, my lord, due to, my lord, pay revision. Now, obviously, my lord, a cut-off date has to be fixed, my lord, for all the employees cannot be granted. That was put to challenge. Now, here, my lord, the Honorable Single Judge, my lord, relied upon, my lord, the dictum of the apex court in DS Nakara state. And thereby said, my lord, that the government cannot create an artificial distinction, my lord, that is violative of Article 14. And therefore, my lord, this honorable court, my lord, the order in which is put to contempt, my lord, directed the government, my lord, to extend similar benefits, my lord, to all the eligible persons, including the members of the petitioners association. Now, that order was, my lord, put to challenge before the division.
That understood. Then review also dismissed.
Review dismissed, my lord. Now, my lord, the department perhaps is contemplating to file an appeal. I am, my lord, receiving the instructions, my lord, in piecemeal basis. But in the meantime, my lord, let him, my lord, implement the new incumbent, my lord. Let this matter come after 4 weeks, my lord.
This court has been informed that there has been change in the incumbents holding change of the incumbents who were holding the post at the time of filing of the contempt petition. The Bharadwaj and counsel for the petitioners prays for and is granted 4 weeks time to take steps to implement the present incumbents, which may be incumbents. It is needless to state that before filing such petition, the present incumbents are to be notified with a prayer, with a request for compliance of the order in place.
I am obliged.
Your item number 32, Jyoti Prasad, Sri M.K. Boro, Learned Counsel for the petitioner submit that due to efflux of time and certain developments, this petition is thought to be withdrawn with liberty to file a fresh. Also heard Ms. Terangpi, Learned Counsel for
Education Department or secondary.
Senior Counsel, Education Secondary Department, and Sri R. Borpujari, Learned Senior Counsel Finance Department, who do not object to the said prayer. Petition accordingly dismissed on withdrawal with liberty as paid for.
May I please, in this case, we got some time to take from the petitioner.
16 matter, 17 matter.
Yes, if the order has been complied or not.
There's anything
No,
you
my lord, we didn't receive any instruction.
Because the
Sri H.3 Learned Counsel for the petitioners prays for some time to obtain instructions. List after 3 weeks.
already requested the file to pick up and jointly.
Your file.
Already requested the
Oh, okay. Sri S.K. Gustami, Learned Counsel for the petitioner, has submitted that due to change in the incumbents, steps are being taken for notifying. Steps have been taken to notify the new incumbents. Whereafter, implement application would be filed if necessary. List after 4 weeks. Yes.
Lord, I am for respond number 6, headmaster.
Yes. Yes.
That matter, court is provided has been shown in the office note. But actually, Lordship, the service has been rightly been made, and respondent number 5 have received, and respondent number 6 has also entered.
So there is a report in your favor.
Yes, Lordship. Lordship may fix a date for that.
You are for?
I am for the headmaster of the school.
And 6 has already appeared.
6 has already appeared.
You are for 6.
6.
Who is 5?
Lordship, respondent number 5 is the president of the managing committee. There is a.
Yes, Mr. Bora. Affidavit file.
No, after 20.
No, affidavit has been filed. Who has filed affidavit?
I have filed affidavit.
6 has filed affidavit.
6.
6 has filed affidavit.
Yes.
Anyone else? Anyone else filed affidavit? No. Yes. 6 has filed affidavit.
Lordship, I have not received affidavit.
No, I have given them copy, my lord. Only one more thing.
SP Bhattacharya, petitioner advocate, Tabassum Akhtar Ahmed, your colleague, she has received for Air Bhuyan.
Okay, Lordship, I will look into it.
Office note, order dated 29/5/2023 of the Learned Lozima Court reflects that service upon respond number 5 and 6 are complete. In fact, Sri Hamad Learned Counsel has already entered appearance and also filed affidavit for the respond number 6. List for admission after a week.
Yeah, after vacation, will be
17 matter.
Just after vacation.
You filed your affidavit. What is the difficulty?
I don't have any difficulty because these seniors, my lord, He had consented means that matter may be listed for vacation.
The consent will not be material in a matter of
My lord, leave it to your
2017.
lordship.
After a week, 17 matter had it
My
been,
lord, my lord,
on the next date we'll see if it goes after the week.
my lord.
Last topic is on this court. Hard to the second time.
No, Sisti was there. Sisti. Yes,
Court number 2, my lord. I may be allowed to call it.
we'll call this again on Monday.
Okay,
Asking me to those three S.K. Goswami, Senate Counsel for the petitioner is present, comma. 3 SMT Sisti, Senate Counsel, who had taken time on the earlier occasion to obtain instructions, is not present. Is not present. Could not be present as informed by his colleague MS Terangpi. In the interest of justice, list again on Monday. Yes. Contempt matter.
Then 5, 15, 5.
Affidavit filed. Where's Mazumdar? Katania, you're appearing.
Same, my lord. Here, altogether 10 petitions, my lord. All of them have been accommodated as teacher.
Teacher?
Yes, my lord. They have the qualification, so they have been accommodated as teacher, my lord. In fact, my lord, I'm not sure whether this affidavit is on record or not, my lord. In fact, here,
Have you filed?
Mr. R. Mazumdar, he is appearing, my lord. He instructed me that the affidavit has already been filed, my lord. In fact, on 19/5/2023, maybe, my lord, there may be some misunderstanding, my lord.
B. Bhuya, that is Senior Counsel for the petitioner. No, don't say that. Wow, don't say that. While MS B. Bhuya, that is Senior Counsel, is present for the petitioner, comma, 3 N.J. Khatanier, Learned Counsel, submit that as per information given to him by Sri R. Mazumdar, Learned Counsel, who was appearing for the respondents in this case, comma, the affidavit has been filed. However, this said affidavit is not with the record. For the further, MS Bhuya, the Learned Senior Counsel, submit that no copy of such affidavit has been served. In view of that, list this case on what is the next.
Yes, ma'am. I'll ensure, my lord.
By which time the affidavit, if not filed, be filed and be tagged with the record.
Yes, ma'am. Obliged, lordship. State, my lord. Here is the otherwise same, my lord. There is a direction from this honorable court, pay the salary. Payment portion is that
Other side has been served.
here, my lord, restaurant number 1, he has been accommodated as tutor, and the number 2, although he has also been offered the appointment of tutor, in the meantime, he has retired, my lord.
Have you taken steps for response number 2?
State was taken, my lord, but none has appeared. My lord, promise,
Take fresh steps upon response number 2. 1 has been served. Order dated 3/12/2021 passed by the learned Lozima Court reflect that though service upon response number 1 has been held to be complete. No, don't say held. Is complete, comma. The state service could not be ascertained. State service, completion of the state service upon the response number 2 could not be ascertained, as neither the AD card nor unserved notice has been received back. Full stop. Under those circumstances, comma, 3. NJ Khatoni Adjournment counsel for the review applicant is directed to take first step by register post to upon the response number 2. List after 4 weeks, along with service report.
problem.
May I please your lordship?
What's your appearance?
Yes, ma'am. Regarding this matter, kindly, I beg apology due to some personal difficulty today morning. Mr. Pritam Saika has informed me he is unable to appear. My lord, this is not possible for me to file an IA for exemption. My lord, kindly, if IA is necessary, then I will file tomorrow or day after tomorrow, my lord. Matter may be taken day after tomorrow, my lord. Otherwise, we have filed one affidavit, my lord. Compliance order has passed, my lord, regarding this contempt petition, my
Lord.
Already he has retired, ma'am, from the department. And compliance order has passed to 30 January 2020, madam. Please,
Where is the order?
in the affidavit. Seven.
You file affidavit?
Yes,
14 June.
today morning.
But he was supposed to appear.
Madam, due to some personal difficulty.
What
He has
difficulty?
some health issues, madam.
Ask him to come day after tomorrow. If there is an order of the court, we have to abide by the order of the court.
Due to some health issues.
Day after
madam.
tomorrow,
Day after tomorrow.
Friday. But
Madam, another thing is that, madam, order has passed in the year 2015 and contempt petition was filed in the year 2018. Madam. After 1
see,
year.
these matters are matters for on merits. But right now we are concerned with an order of 10/5/2023 by which he was directed to appear. We should have objected while this order was passed. In fact, we close this petition, but we cannot allow our orders to go like this without compliance.
And the day after tomorrow or any other day, madam, you will definitely appeared,
Because
my lord.
30th of
Again,
January 2020
I
order
am
is a,
assured, yes,
is a speaking order.
my lord. As per this speaking order already,
Yes, you need to challenge this speaking order.
yes, they can also, it can be also, my lord.
No,
No,
it
my
was
lord, earlier,
it was
at the last,
produced it was produced on the last
no,
date
my lord.
10/5/2023.
Yes, my lord. At that time, I have, on that day, I have, no, no, they said, no. Last occasion, I have given.
When did he retire, Mr. Secretary?
In the year 2021, my lord.
21. You have served this copy on your colleague, Mr. Islam.
Yes, my
We served heard Riyas Islam, Senate counsel for the petitioner. Also heard MSN Fukan, Senate counsel for the respondent. Also, the order, the contempt petition pertains to an order dated 9/6/2016 passed by this court in WPC 6805/2015. Also, the operative part of the order is extracted here and below. Page 24, pencil mark for us. Para. This thereafter, this contempt petition was filed in the year 2018, which is pending till now. Also, para. This court on the last occasion, while recording the submission of the learned counsel for the respondent, that the order of this court was complied with and a speaking order was passed on 30/1/2020, a copy of which was produced, this court had noted that no affidavit has been filed in this case and personal appearance was also not dispensed with. Accordingly, the respondent was directed to appear in person today with an affidavit. Para. MS and Pukan, Senate Council has submitted that the affidavit has been filed today. However, due to certain health issues of the respondent, he could not personally appear, for which he has thought he had tendered apology. Para. In the affidavit filed today, A copy of the order dated 30/1/2020 has been annexed. By the aforesaid order dated 30/1/2020, comma, a decision has been recorded after recorded after after note after putting not in the said order, the findings and decisions have been recorded. This court this court is of the opinion that since the order of this court should comply with by passing of the order dated 30/1/2020, comma, 2020, which has been placed on record by way of an affidavit, comma, the contempt petition is would not be maintainable. And the contempt petition is not maintainable. Full stop. Further, comma, since the order in question had existed as on the date when the order as on the existed when the order dated 10/5/2023 was passed by this court, comma, and further that personal appearance was directed only because of the fact that the same was not dispensed with, comma, this court accepts the apology tendered. Accordingly, the contempt petition stands closed. However, it's a liberty to the petitioner to challenge the legality of the order dated 30/1/2022 in accordance with. Madam, was an exceptional case we have done. Otherwise,
This case that the respondent my lord has be taken. I may be given, I may be allowed to
you challenge the order. You challenge the order. There is no question of counter. Contempt is on a very limited scope.
That decision, my lord, that decision has not been complied with this order of.
That is the subject matter of challenge. You have to challenge it. We have given you liberty. Madam, you tell your client this is exceptionally you have done.
Only because of
Compliance
his
part is a different matter.
My lord.
And court order for personal appearance in no condition will be lenient.
No, but today morning he has informed me, my lord. Sorry, ma'am.
Next.
My lord, by this application, two things I have done: the suspension order, as well as my lord, the trial of a department, purported department. Suspension order, my lord, they have reinstated. They have reinstated me on 8/12/2022, my lord. So that part, my lord, I have not moved grievance. Now, my lord would see the department.
Yes.
My lord, that is at page 26.
26.
26 by the inspector.
Yes.
In exercise of powers conferred by government notification at 9/12/1967, the undersigned hereby asks you to propose under Rule 6 of the Assam Services as to why any of the aforesaid rule should not be inflicted on you on the following charges on the statement of allegation attached here. There was no allegation separately. That a complaint received from the guardians also regarding misappropriation of government fund, irregularity in implementation of so and so, non-cooperation of members of the assembly, which is also finding on spot verification of so and so, as directed by Commission and Secretary Government of Assam, so and so receiving complaint from the locality. You are therefore charged with involvement of the above activity. Hence, you should submit your written statement in defense within 10 days from the date of the Madam, this is nowhere near royal above proceeding under section rule 9 of the rules. Madam, I have replied to that also in detail. And this, Madam, they have not proceeded there. So I'm praying, Madam, that this cannot be sustained. Madam, if there are any material against me, Madam, let them come up with a fresh.
Yes, what do you say? Who's defending this? Which department? Secondary.
Education.
Secondary.
Secondary.
Yes. What is your stand?
Obtain the interest.
Affidavit filed.
No, my lord.
Is that coming from a long time?
They have not proceeded.
No, they have not proceeded. Now, what is happening, Madam, because of this purported thing, my that suspension period is not being regular. I don't have much time.
See, normally DP we do not we are not inclined to interfere. But here it seems there is some lacking, inherent lacking in the show cause notice.
And nothing is there, no allegation made. But if they have something, man, let the malady give them that report. Yeah, no. I can't.
And from 18 till now, even if we ignore that aspect of the matter which Mr. Nair is harping, from 18 till now, in spite of there being no restraint order, you have neither accepted nor rejected the reply. That means what does it mean? Then you don't want to proceed. You could have rejected the reply, initiated an inquiry. You have not done so.
The last chance, my lord, next week.
Next Tuesday for disposal. Part 3, UK and Ireland Senior Council for the petitioner who has put to challenge an order of suspension as well as an order dated 6/4/2018 by which a disciplinary proceeding has been initiated. It is submitted that during the pendency of this writ petition, the first grievance with regard to the suspension has been redressed. However, the second grievance with regard to the validity and legality of the disciplinary proceeding is still existing. Assailing the show cause notice dated 6/4/2018 by contending that the same has been issued in gross violation of the rule, the petitioner had submitted his defense on 13/4/2018. Until now, there is no communication regarding the fate of such reply. He further submits that since the reply has not been rejected and a departmental inquiry initiated, the reply may be deemed to be accepted and the proceedings be dropped. On the prayer of the MS Parang, Learning Council, Secondary Education Department, matters stands adjourned. to be listed on Tuesday. On which date, an endeavor would be made to dispose of the writ. Senior Counsel out of stage, why are you smiling? Have you prepared the brief? Why? Brief is not with you. What are the facts? What do you do? Petitioner serves their is in service. What is the post he is holding? Which college, school, which one? Bordupi or Sanairam? Which one? Right now, Sanairam. Who is the senior? 18 matter, madam. We'll have it on Friday. And come prepared with facts. Not that difficult. On request, please on Friday.
By
You have lost contact with the petitioners. And are you really interested in pursue this? Are you interested to pursue this? You know the cost of publication in a newspaper. How much? Who will pay? Not at one issue. It's your submission. We cannot force you to go for paper publication.
there was a direction earlier. That is,
Which direction?
audited for 1,000 pages.
You you decide and make the submission on Friday. If you want to withdraw, you can withdraw this. We'll close it with liberty. Or shall we close it now? Matter pending since when? 19. No contact. What is the review you are seeking?
It's against the operative under page 48. There is got some example an advertisement dated 14/8/2009. They say that whose case was not they not be able to participate in that advertisement.
We'll do one thing. We'll close this for want of instruction. We'll give you liberty to revive. Heard free MP Sharma, Senate Counsel for the petitioner. Also heard MS Terangpi, Senate Training Council, Secondary Education Department. This petition for review is pending since the year 2019. The review sought is with regard to an order dated 29/8/2019 passed by this court in WPC 6168/2019. The operative portion of the operative order is extracted herein below. Certificate of yes. 1, 2, 3, paragraph 11. The Sri Sharma, the learned counsel for the applicant, submits that the aforesaid observations and directions are liable to be reviewed as where you heard as the same would affect the applicants who are not made parties in the recruitment. Sri Sharma, however, has candidly submitted that the review applicants are not in contact with the learned counsel, and this fact was also reflected in the earlier order dated 27/3/2023. Para. In view of the above, in view of the above, and also taking into account the limited scope of a review court to review each judgment, this application is dismissed for want of prosecution. However, if the applicants want to pursue, liberty is given for revival of the same. To last day, so it will be order Yes, 45. Madam, after 45, 20 matter, okay. On the prayer made on behalf of the applicant, list of certification. Three, as the standing council, higher education is present. 46, certain year.
The review prepared by the state level. Taking review of the order dated 19/11/2019.
Take some time.
But
No, will it take some time?
Yes, sir.
How much time?
For photo pass, half an hour.
Today you have to dictate the judgment.
Take it up any other day.
Tuesday? What is the matter? What review?
Because
Oh yes, Mr. Chaudhary, what was the direction?
Lordship, in this particular petition was filed for correction of the date of birth. And accordingly, when the petition was moved before this honorable court, if it was not filed, accordingly, this honorable passed an order because the Sheva certificate was there. All the documents were there favoring the contention of the petition. Accordingly, that was allowed. This honorable court had directed the authorities to correct the date of birth. Now, after 2 years, it was passed in the year 2019. For 2 years, they have preferred this review application, stating that that particular order, which the petitioner had relied for correction of date of birth, that was subsequently cancelled. Since the affidavit was not filed, that was not brought in record before this honorable court. But this opposition in the affidavit in opposition, we have said very specifically, this cannot be a ground for review. So there was no error apparent on the face of the record. Another point they have raised, that if the date of birth is being corrected, the entry age of the petitioner would be 9 years. So that aspect of the matter was not taken into consideration by this honorable court while disposing of the writ. This is the basic issue.
He entered into the service at 9 years.
But that was not regular. Subsequently, it was regular.
What post?
That was.
Now he is in grade 3 post.
Grade 3.
Earlier, his initial appointment in grade 4.
Now, what is your age?
Now,
You have retired.
no, I'm not retired. I'm still doing my job. So if that age is to be taken into account, then I am going to be retired after 2 years now. 2 years.
But is it a fact that if all things granted, your entry into the service would be 9 years at the age of 9?
Yes.
And from 9 to 18, you will.
Yeah, exactly, Lord.
9.
That is our point. 9 to 18 should not be taken into account. After that period, it can be taken into
9
account.
to 18, don't take into
Exactly.
account.
Yes,
9 to 18, you recover the salary.
because I was doing the job during the relevant period of time. There is no
Recover
denial
the
with regard
salary.
to that. No, there is no denial with regard to the fact that I was not doing the job.
That you cannot do a job.
But my service
You
was
cannot
taken.
have the cake and eat it too.
No, that I can understand, Lord.
You can have one.
But my service was taken, Lord.
Service is taken what? Legally.
Not legally, it's a
If you want the salary, then you have to go. If you want to stay, then leave the salary.
Then Lordship fixed it on Tuesday, I'll opt in the next week.
See, illegality of this kind we cannot.
Exactly, Lordship. That I have taken
Within
this point in
the
the
four
affidavit
corners of
opposition.
review,
Yes.
we will try to do ensure justice is done. Not only to the department, even to you. Okay. As agreed to by the parties, based on Tuesday. All is. All right, also. Did you? 40. I for what?
I am the my lord respondent number 5.
I for who is your senior?
The earlier occasion, my lord, or prior occasion, my lord, matter was my lord for
I for what?
I for my lord some matter action some documents for and amendment matter.
I is come for the first time.
Lord.
We have it on Friday. Amendment of the prayer.
Already my lord, 6th occasion time, my lord, they have filed my lord affidavit of activity. Already my lord, provisions are completed.
What is the amended prayer, madam? What was the earlier prayer? Madam, this is an entirely different cause of action to set aside a resolution. This cannot be a part of the, you cannot change the nature and character of the case. That is the principle involved. In an amendment, you cannot change the nature and character. For that, you can file, always it's open for you to file a fresh writ petition, get the new writ petition tagged with this. Okay, we'll have one Monday. A prayer for adjournment has been made on behalf of the applicant. Three, here for whom?
Respondent number 5.
3 as the Standing Council Higher Education. And 3. Alan Dehinga, Planet Council for Respondent 5 are present. Please for consideration on Monday. Monday.
Right.
Lord, in this case, I'm a little bit handicapped. In fact, I wanted to reconstruct the file from the other side. Now, they are also not responding. In that case, well, if your lordship permits, my lord, reconstruction from the record, my lord, lordship can
Records,
pick up.
we can,
Yes, I can understand, my lord.
we can give you to inspect, but you cannot take
Yes,
photocopy.
so, my lord, in that case, my lord, I may apply for certified copy. Lordship will give me some reasonable time.
17 matter, what is the review for?
Lord, in fact, I recollect, my lord, that the order which was impugned. my lord,
Attorney is appearing. You are appearing. Who's there for the other side? Elementary. Who is for the elementary education? The Talukdar is this matter of 2017.
I understand. Sorry, my lord. Yeah, that is misplaced, my lord, could not be traced out. In fact, on the last Monday, it was listed, my lord. I tried to recontact it, my lord, but
Do you have copies, Mr. Katonier? You don't have.
also don't have.
Okay. Sri S.K. Talukdar, counsel for the applicant, submit that the file has been misplaced. Yeah, same submission. Okay. Don't write. When this matter had, when this matter was listed last on 12/6/2023, this court had recorded the submission made by the learned counsel for the petitioner that the file could not be traced out. Sri S.K. Talukdar, sir, Sri S.K. Talukdar learned counsel submits that the situation is still the same and he is yet to reconstruct the file and accordingly prays for some more time. Under those peculiar circumstances, under those peculiar and extraordinary circumstances and exceptional circumstances, this court grants time of 2 weeks to reconstruct the file.
I'm okay. I'm sorry, my lord.
Rest of the 2 weeks. We'll pass the orders today, sir. Both that order. We'll pass it to him.
But I'm sorry, my lord, for
Which one?
today, my lord, I was not prepared.
Okay, to you. Okay. It. Right.